Do we have our court reporter with us?
Yes, we do.
Okay, thank you. What is your name?
This is Gerald Aragon.
Thank you. Are you ready to begin?
I am, yes, sir.
Thank you. Do we have our technical examiner? I think it's Mr. Fordyce with us.
Yes, Mr. Hearing Examiner, I'm here.
Okay, fantastic. Are you ready to begin?
I am.
Thank you. Freya, are you ready to begin?
I'm ready.
Okay, fantastic. Let's get on the record. I'm calling case number 25610. Entries of appearance, please.
Good morning, Mr. Examiner. Ben Holiday for the applicant Powderhorn.
Good morning, good afternoon, and welcome.
Yeah, just
Adam Rankin and my colleague Paula Vance with the Santa Fe Office of Paul & Hart appearing on behalf of Marathon Oil Permian.
Thank you. Ms. Vance, were you pointing to someone?
The case prior to us.
Are you before?
Yeah.
Okay. Okay, then we will be in recess. Well, you guys were sitting back there and I didn't know you want, okay. That makes sense. So let's go into recess on 25610. I don't have the case number. Ms. Hardy, what is the case number I'm calling? It's the Chevron case. What is it?
It's the Chevron case.
25878.
25878?
Yes.
Thank you. Entries of appearance, please.
Good morning, Mr. Hearing Examiner. Earl D. Bryan with the Modules Burning Firm on behalf of the applicant, Chevron USA, Inc.
Thank you.
And Dana Hardy with Hardy McLean on behalf of PBEX and EGL Resources.
Thank you. We are here basically to understand what are the issues going to the hearing, because at the last time we got together, I had ruled that Chevron had standing to proceed in its case. There was, I think we were virtual. Must have been the February 26th docket, and there were some claims of additional discovery needed. And at that point, I asked, what are the issues that are going to a hearing? And I don't know that the parties had a chance to stipulate to the issues moving forward. Have you done that?
Mr. Hearing Examiner, we have conferred, but I don't know that we have unanimity with regard to the issues to be presented. But I think if I may just briefly, I think the division's order with regard to the motion to dismiss pretty much defined the issue in its order. And that is, it is recited that the statement of well costs that Chevron received is legally deficient because it was issued by unauthorized entity, contained inconsistent well data, and omitted material information regarding the rescission of phase 2 wells for other parties. So that is the main issue in the case, is the sufficiency of the statement of well costs. And there's a variety of sub-issues with regard to that. The other is with regard to the operator's obligation of good faith in order to comply with the division's compulsory pooling orders. Ms. Hardy has also identified a key defense that they're raising is the waiver. So that's another issue. But I think beyond those three issues, I think those are the main ones for the division to decide at the evidentiary hearing.
Before I hear from you, Ms. Hardy, it was my understanding, Mr. DeBrine, that you were really focused on two conditions of the compulsory pooling order. And those two conditions, I forgot if it's 25 or 26, 26 or 27. What were those two?
Well, the statement of well costs with regard to one, what it needs to include.
What condition was that? What number was that in the?
It's paragraph 24
That's
of the order. It's the one that obligates the operator to submit a statement of well costs. And then paragraph 25 then deals with the election and payment of well costs by the pooled working interest owner.
And Chevron's contention was, since PBEX did not comply with 24, their argument that you that you violated your obligation to timely notify them of your consent, non-consent, it should not disqualify you from, in the future, consenting and potentially devaluing your mineral estate. So really, we're focused on conditions 24 and 25. Is there anything outside those conditions that you feel is important that we hear at the contested hearing?
I know, Mr. Examiner, other than what I already identified
Okay,
as
fine.
sub-issues within that.
That's fine. I'm just trying to get the broader picture here so we understand about discovery and how we're going to proceed. How many witnesses do you anticipate?
I believe we will have probably 2 and possibly 3.
Okay, and what fields of expertise will they be?
With regard to land matters and with regard to business practices.
Okay, all right. Okay, Ms. Hardy.
Yes, thank you, Mr. Examiner. So I think I don't disagree that those are the issues that Chevron is raising, but here there are 2 major issues that I think are potentially dispositive of the need for a hearing at all. And one is waiver, because all of Chevron's arguments relate to the post-order well proposal election letter, which includes the estimated statement of well cost, that it signed. Chevron signed the election letter and returned it. And they elected to participate, and then they just didn't pay their share of the well cost when they were due. So I think by signing the election letter and agreeing to participate, they can't come back now and argue the wrong party sent the letter didn't include our share of the working interest, the estimated well costs were insufficient, they signed the actual AFE for every well. So it's a very clear case of waiver, and we would plan to file a motion for summary judgment on that. And if it's granted, and I think it's a very strong case of waiver, I just think they waived their arguments. There's no need to have a hearing or conduct discovery. So I would request that that issue be addressed first. And the other issue that I think they are raising is whether there is a good faith negotiation obligation after a pooling order is issued. That's what they're raising, and that's never been held by the division. And it's not in accordance with the compulsory pooling statute, which says you have to reach a voluntary agreement or try to before you pool. Once the parties are pooled, they are pooled under the pooling order, and that's what it says. Then you comply with the requirements of the pooling order, which are sending out that statement of estimated well cost. There's not, so it's a novel issue. It's never been adopted. And so I think that's another issue that's potentially dispositive. But I think they waived that issue as well by agreeing to participate in the wells and signing the election letter.
Okay, so you would like to brief the issue on waiver and possibly the good faith dealing that condition 24 might or might not impose on PBEX.
Correct.
And Mr. DeBrine?
Yes, Mr. Hearing Examiner. The question is, how many bites at the apple are you going to allow EGL and PBX? They already filed a motion to dismiss, raising what they said was the threshold issue. Now they've identified 2 other ones. Both of those are fact intensive. We could cite to you a half dozen cases that say waiver is a question of fact. It precludes summary judgment. The same is true of good faith. The division's rules don't provide for motions for summary judgment. You're going to open up a box of Pandora's, as our former governor once said, if you're going to allow seriatim motions practice with regard to issues that a party identifies in a compulsory pooling case or any other case. And the division's rules don't provide for it. It provides that you file an application, division sets an evidentiary hearing, and then you decide the merits. And all these matters are fact intensive and should be addressed at a merits hearing based on the parties' mutual availability to appear and the divisions.
Ms. Hardy, specifically to the point that the defense of waiver is fact-based, what is your answer?
Here, there are no issues of disputed fact on that. I think it's very clear. They've signed the election letter. Now they're raising claims about the election letter. I don't think there are any facts in dispute. I think it can be a factual issue if there are facts in dispute, but here, I don't think there are. that are material.
So your contention is, once you sign the letter, that's the fact that matters,
Right.
is you've signed this, and I'm not familiar at all with these letters. I don't know what they say. But of course, a good attorney could always find some loophole somewhere in these letters to say, well, this or well, that. So I'm not, my interpretation of the letter is I don't think it has any weight here, but you're saying there's no other fact that matters.
With respect to waiver of the, yes, claims regarding the.
And your
election letter.
argument, of course, you haven't made it yet, but simply, you said, obviously you've thought about this argument. Your argument is, once they sign the letter, consenting, because it's a letter of consent, is that right?
Correct.
Okay. They're now committed and you better pay, because if you don't pay, you're now non-consenting.
Under the pooling order, correct.
Right. And Mr. DeBrine, your argument?
Well, there's a variety of factual issues with regard to that particular question. One, the letter, you're consenting with whom? Who are you entering into an agreement with? The division designated an operator, gave rights to an operator, which are extraordinary powers to compulsory pool and develop somebody else's property. That's not who the letter was sent by or on behalf of. That's an issue that we raised with regard to the motion for standing. You have the reshuffling of the deck. The division authorized specific wells, considered them in an evidentiary hearing, considered the well costs, and approved the plan. Then they reshuffle the deck. Is there any authority whatsoever for the additional wells that were never proposed or considered by the division in the original hearing date? And then you have this issue of constructive fraud, where they don't even tell the pool parties that they're suspending the second phase of the drilling plan, so that you don't even need to make an election with regard to the phase 2 wells, that they're telling other operators. And they're telling other operators before the date that the time in the order is for the payment of well costs. So there are a host of factual issues that need to be considered in an evidentiary hearing. And waiver, you can say there are no facts, but there are numerous facts underlying the issue of waiver, in addition to the ongoing dialogue and negotiations that was going on between the parties that led Chevron to believe that there was no obligation to pay any well costs whatsoever.
What I'm trying to understand here is the argument that Chevron signed this letter consenting to whatever was in the letter and didn't do their due diligence before signing it. So I can understand if once you sign a letter and then you have to make these other determinations after you sign the letter, then I could see those facts being material. But and Chevron is not it's not a mom and pop store. I mean, it's a sophisticated operator in the oil field. So I could even understand the argument of, hey, the person who signed the letter had no authority to sign the letter. But if someone at Chevron signs a letter and there's agency between the employee and the company, how is it that Chevron is not bound by that consent? I understand you're saying, and that's why I found that you had standing, because I agreed that potentially these matters should have a hearing. But when it comes to waiver, and I don't even know that waiver applies in this circumstance, so I don't know yet. That hasn't been briefed, and so I'm just taking Ms. Hardy at her word. But I mean, I know waiver is a defense in many civil forums, and so maybe it applies, maybe it doesn't. But how do you argue what you just argued as post-signing instead of due diligence before you sign?
Well, there's two issues. One, just in a normal garden variety contract case, people sign contracts all the time, and they raise various issues as to why they're not bound by that contract. Fraud, constructive fraud, authority to enter into contracts, all those issues are present in this case. We've got constructive fraud with regard to the failure to disclose the suspension and rescission of the second phase drilling plan that was never disclosed. We have ultra
You
virus
said that already.
authority.
I heard you the first time, but I think what you're saying is waiver, even if Ms. Hardy is claiming that there's a waiver, it doesn't necessarily mean that there was waiver if you have this other stuff going on. I think that's what you're saying, right?
Correct. All those issues vitiate any consent that may have
Yes, I get.
existed just by
Okay.
signing the letter.
Okay, I hear you. And I don't know the facts and all of that, but I can understand how you're saying waiver doesn't apply and Ms. Hardy is saying waiver does apply. And that's really what you're both saying here. Okay. Now, Ms. Hardy, I still would like some confirmation. The whole point of today's status conference was to confirm the issues that may go forward if I don't find waiver as a bar to moving forward, or your other issue of good faith dealing under the order. Okay. Do you agree that it's clause 24 and 25 in the ordering paragraph in the order that will be controlling the evidentiary scope of this contested hearing?
Yes, I believe that that is correct.
Okay. Now, was it you or Mr. DeBrine who said, oh, we need more discovery?
Well, I had said that, and Ms. Bennett had said that we don't need more discovery, but then I received a subsequent email from Ms. Bennett yesterday listing a whole bunch of discovery that they
Okay.
want.
Okay.
So I think that both parties want more discovery.
Okay. Okay, fine.
Significant, really, I would say,
Okay.
on both sides.
So that being said, Mr. DeBrine and Ms. Hardy, can you get together now that we know what the issues will be? If we get to a hearing, if we get past the waiver defense, if that is a defense, in light of your allegations of, bad faith dealing and bait and switch, et cetera. When do the parties want to have this hearing? I mean, I know, Ms. Hardy, you don't want to have a hearing at all, but let's start with you, Mr. DeBrine. When do you want to have a hearing?
Well, I believe at the last hearing, the division proposed two dates, one in March and one in April.
Mhm.
The March date does not work for Chevron, but I believe the April 21st date will work for us.
Fine, April 21st. Does that give you enough time, Ms. Hardy, to file your brief on waiver? And I'm not telling you it has to be on waiver. You can file whatever you want to. But does that give you time to file your pre-hearing brief? That, or summary judgment, let's call it. Let's call it a summary judgment motion.
It does, but I think that the ruling on that motion is going to have a big impact on what the parties do in discovery and at the hearing. So I just really feel like it would be more efficient to have a ruling on that motion before we have a hearing setting. So allow for enough time.
So are you saying that you can't conduct discovery at the same time?
We can, but I think there are going to be discovery disputes probably based on the lists that I've seen. And so I think that more time would be preferable to do that.
Well, I, as you know, Ms. Hardy, I like to move cases along when practical. And I can understand Chevron's perspective that they're now stuck in this. What do you call that? Between, that's a term. Yes, I was thinking of purgatory, really. I don't know why I was thinking of a religious context, but there it is.
I
They're
think
stuck in
we're probably
purgatory.
in the fifth circle of hell right now.
Yeah, I was going to agree. It's not purgatory.
So I'd like to find a way to move this along to an April 21st hearing. So we have an agreement on the issues. We have an agreement that there's going to be some pre-hearing briefing, briefing, pleadings, and that there's going to be some discovery issues here going on. How soon, Mr. DeBrine, can you confer with Ms. Hardy and come up with a list of agreed upon or not discovery items that both parties want?
We could submit something to you tomorrow. We've already conferred But I don't think there is any agreement with regard to pre-hearing motion practice. And I would caution the division to not open that up for every case for parties to file motions for summary judgment. The issues are very discrete. We might have 5 or 6 witnesses, 3 on each side, a half-day hearing. You know, let's just have the hearing, and the division might be educated by a pre-hearing brief from both sides because it'll help guide the hearing examiners and technical examiners questions they may have. But we don't need motion practice with regard to dispositive issues, particularly when we've already had it. And we don't need to have seriatim motions to dismiss in cases. If these were issues present when the first motion was filed and could have been raised in that motion, we could have already had a hearing to address them. We're just wasting the parties and the division's time through the proposed motion practice.
Can I respond?
Of course, definitely.
Um,
But I was just
yeah.
thinking, but before I ask for your
Yes.
response, I was just thinking about what Mr. DeBryan just said. You know, Mr. DeBryan, the division's here to give the parties a meaningful opportunity to address their concerns, issues, et cetera. So it's not wasting our time to hear this thing, first of all. Second of all, based on what Ms. Hardy was saying, their defensive waiver is based on a single fact, which is not in contention. I mean, I know what you said, but it's not in contention that someone at Chevron signed something that said something, okay? Now, you, I know, have a position, a different position to take, but that seems like a legal position. And I don't think we need to have a hearing with 5 witnesses to flesh out the summary judgment if we heard a summary judgment motion. So I don't see that as a problem for the division. Now, maybe it is for Chevron, but I don't see it as a problem for the division. Are you saying that, Mr. DeBryan, that you would not respond to a motion for summary judgment if it filed by PBX?
Well, we would obviously comply with any ruling the division were to make,
Mhm.
but then we would file motions for summary judgment because we think the facts are undisputed on all the issues that we raise. It's just interpreting documents. So let's file 4 motions for summary judgment on the issues that we raised in response to the motion to dismiss for lack of standing. It's the same thing. We're going to have all these motions for what, when all we have to do is come here for a half day and consider the evidence, and the division can make the ruling that it feels appropriate based on the evidence and any hearing briefs that get submitted.
So, Ms. Hardy, you have 2 things to respond to. The original thing, hopefully you can remember, and now this over here. Go ahead.
Well, I was just going to say that there's certainly no prohibition on filing motions, dispositive motions before a hearing. And I think it's respectful of the division's time for us to do that in the event that it can narrow the issues at hearing. And our initial motion actually to dismiss was filed in response to the division's inquiry about standing. So we certainly weren't waiving other defenses by filing that motion. And I think it will be very helpful for us to file a motion on waiver. With respect to the hearing, given the issues that Chevron is raising, which seek to really create new requirements on operators, particularly with respect to post-order negotiations, I think this is going to be not a half-day hearing. I think I'm not sure how many witnesses we will have. They've raised issues on industry standards. It's not just between these parties. They're raising industry standards, which is part of the reason we're going to ask for broad discovery on well proposals they've received, well proposals they've sent, because they have injected that issue into the case. And so I don't think it's a short and quick hearing. I think it's potentially a couple of days.
Okay. All right.
So
Okay. So first of all, unless I hear a really good argument not to set this for April 21st, I'm going to set it for April 21st. Freya, do we have anything else on the April 21st docket?
We do.
Oh, we do. Okay. Well, we had 5 things on today's docket and there's only 1 left. So we'll set it on a trailing docket. This will be the last case on the trailing docket as it sits now. How many do we have ahead of this?
pulling up the list now, but I believe there's 4.
Oh, another one of those. All right. Ms. Hardy, how long do you need to file a motion for summary judgment based on your waiver argument?
Just looking at the calendar, I think I could do that in 2 weeks.
Okay. And Mr. DeBryan, your response?
My response is I don't know what procedure I'm to follow when I see that motion. The
Okay.
division has no rules on motions for summary judgment. If we're going to follow the New Mexico Rules of Civil Procedure, a party in receiving the motion, they get 15 days. They can file a Rule 56F affidavit saying they need additional discovery in order to respond to the motion. We're just opening things up, which I think unnecessarily. And so if we're going to follow those rules, then I think the division needs to have a rulemaking proceeding and adopt those rules rather than ad hoc in connection with a single case, impose litigation style rules for this case. It's unnecessary. And it might be a full day hearing. I agree with Ms. Harding now that she's indicated that there might be additional witnesses, but we don't need any pre-hearing motion practice. But if we do, then Chevron would want the opportunity to file its own motion for summary judgment. And I think all of the issues that we identified in response to the motion to dismiss for lack of standing, which concern the deficiencies in the well statement and the rescission and change in the drilling plan, those will all be raised in a dispositive motion as well.
So Mr. DeBryan, I understood you to say a minute ago that you had certain defenses to the argument of waiver. And I assume those are legal defenses, right?
Well, it's the application of law to facts. There's factual issues underlying them,
But Miss,
as there is in any case.
okay, but Miss Hardy's summary judgment motion would be based on the single legal issue of waiver, based on the single fact that someone at Chevron signed this piece of paper and therefore has no right to complain about it after that. So if we have this one fact that is not being contested, the fact that there was a signature, are you saying your defense to waiver would go beyond that?
Well, she's calling it a waiver, but the issue is whether there was a binding agreement between the parties based on the statement of well costs. And that depends on, was the party who sent it authorized by the division to do it? Was the wells that were listed in it authorized the division to do it? And was there good faith in actually providing for it when they knew they weren't even going to drill the wells that were in the proposal letter, and they're essentially trying to steal property from Chevron and committing constructive fraud by disclosing their drilling plans, not just to Chevron, but to the division. It's not just a fraud upon Chevron, it's a fraud upon the division when an operator does what PBEX
Okay.
and EGL did in this case.
So haven't you just made the argument now? Didn't you just make the argument that there was no waiver, even if someone signed this thing, that there was no waiver? Isn't that what you're saying?
Yes, there was no waiver.
Okay.
There-
Ms. Hardy, what do you have to say about that?
There's no fraud. There's no constructive fraud. There was absolutely waiver. Well proposals, changing the names of wells happens all the time due to BLM and APD requirements. The order authorized the wells that have been proposed and that were drilled. The proposal was not rescinded. There were adjustments made for one other operator due to their specific situation. There's certainly no fraud on the
Okay.
division or anyone else. And
Okay.
so
I hear
it's a
you.
very clear case of waiver.
So now it sounds like we're getting to the underlying facts of the merits of the case. Really, that's what it sounds like here. So I think what we should do is this. I've changed my mind about how I want to proceed here. We'll deal with the discovery issues right away. We'll go to a hearing. At the end of the evidentiary hearing, you can make your argument for waiver at that point. Okay? So we don't need to have this briefing to try to save us time and effort, because your waiver argument and his defense relies upon the underlying merits of the case.
I don't think it relies on the impact of their signature on the well proposal letter.
I think it does at this point. From what you've said and what he said, I think it does. So I'm inclined to agree with Mr. DeBrine here in that having pre-hearing briefings and summary judgment and all this back and forth, really let's hear the case and then you make your legal argument at that point on why, once we have the facts, their signature prevents them from now arguing this was double dealing and we shouldn't allow that.
Okay,
That's how I see it now, based on what your argument was, and I heard your argument, and based on what his argument is, and the idea of how waiver works in this context, I agree, we need to understand the facts. We need to hear both sides before we can even make a decision. And to do that before the hearing doesn't make sense, because then we're gonna have two hearings. Let's just have one hearing and get it done. So now we're back to the issue of discovery. And I understand that you haven't agreed between you on discovery. But there must be some points that you do agree on. There has to be some points that both parties agree, yes, this would be relevant to clause 24 and 25. And then maybe parties have arguments, do we want this extra, we want that extra. So let's set something where the parties submit something to me saying, here are the issues that we agree, here are the discovery areas that we agree on. Here are the ones that we don't agree on. And here's why we don't agree on them. And a simple short sentence from each party about, we don't agree, we agree, we find this to be relevant, we don't find this to be relevant. So can you do that so I can sign some sort of subpoena so that you all can exchange information and we can hear this on the 21st?
yes.
Yes, we can do that. And we can submit a draft subpoena
Yeah.
going both ways. That way you can
Right.
amend it as necessary based on the rulings. So that-
Based on your arguments
based on the argument and the
about
ruling,
discovery, relevancy,
yes,
and materiality.
that'll make it for easy to you when you issue the subpoena.
Yeah, now, do both of you agree, while I have you here, that when it comes to discovery, my recollection, and it's hazy because I didn't do a lot of this in civil procedure, that something has to be calculated to lead to something that is,
See, reasonably
that's it,
calculated
that's the reason.
to lead to the discovery of admissible evidence.
That's the one. Okay, so we agree on the standard?
Yes,
Yes.
we will apply the same
Fantastic.
standards as in civil
Yes.
Thank you.
proceeding.
Thanks for helping me. I appreciate it. All right, is there anything further on this case?
I just do want to make sure that my witnesses are available on April 21st.
Yeah,
So
you'll
I will
us
let you know if not.
Yeah, we can't force you to a
But-
hearing if your witnesses aren't available. We know
I
that.
haven't checked with them, so I have to do that.
And of course, they can appear virtually, like,
Yes.
looks like Mr. Holliday's witnesses are they here? Two are here. Okay, great. Okay, perfect. So as you see, we're lenient that way.
Yes, understood.
Okay, anything further?
No, we appreciate your time.
Yes,
Thank you
thank
for
you.
hashing it out. It was helpful. Appreciate
Thank
it.
you.
Thank you.
Thank you. All right, now going back to case 25610. Before the parties begin, and before we talk about preliminary, because we do have a preliminary matter in this case, there was a motion filed. Ms. Vance, are you arguing it or is Mr. Excellent? And I saw you.
Mr. Examiner, I think there's some other entries of appearance.
There are. I didn't know that. Excellent. Let's hear.
Good afternoon, Mr. Hearing Examiner. Caitlin Luck appearing for Avant.
Good afternoon, Ms. Luck.
Mr. Hearing Examiner Jacob Eberhardt with Beatty and Wozniak, New Mexico, appearing on behalf of Coterra Energy Operating, Magnum Hunter Production, Inc., and Simrex Energy Company of Colorado, collectively as Coterra for monitoring purposes only.
Perfect. Thank you, Mr. Eberhardt. And Ms. Luck, you're monitoring only?
Yes, Mr. Hearing Examiner, thank you.
Thank you.
Mr. Examiner, Jim Bruce representing Kaiser Francis only. I'm just monitoring.
Yes, I saw you withdrew your objection. Thank you.
Good afternoon, Mr. Hearing Examiner Yaritza Pena with Hardy McLean on behalf of Permian Resources Operating, and we are also just monitoring.
Thank you, Ms. Pena. Are there any others? I saw Ms. Hatley earlier. Was she involved in this case, Mr. Holliday? There she is. Is she?
Good morning or good afternoon, Mr. Exam. I'm so used to saying good morning.
Yeah.
Yes, I am present and Holland and Hart is representing Marathon in this
Right.
case.
Thank you very much. We have a preliminary matter to deal with. So I think let's deal with the preliminary matter. I did have a chance to read the motion to exclude certain evidence as immaterial because the allegation is that it was not, the issue was not in your pre-hearing statement, and the rules require you to have the non-standard location in a request in your pre-hearing statement. I also read your first response. I was in a commission meeting this morning, starting at 9, when Freya sent your updated. What did you change?
I'm a stickler for grammar, so I
Yeah.
fixed a few things.
Okay,
Nothing.
good. All right, good. So meaningfully, it didn't change your response. All right. Okay, so let me tell you, hold on one second. I did an analysis of that. So, Ms. Vance, I'm going to sum up your argument, and then I'm going to sum up Mr. Holliday's argument, because I didn't have a lot of time to do this. This was all done this morning. So I want to make sure I basically understood your position before I make a ruling. So your motion to exclude Powderhorn exhibits A9, A18, and A19, as well as paragraph 30 of Travis Maka's statement, are based on 3 main legal arguments. Number 1, procedural violation. You argue that Powderhorn must include all requested relief in their application under 1915-4-8A NMAC. Powderhorn's application did not seek a non-standard location approval and explicitly stated it would seek such approval administratively instead.
Correct.
Good. Number 2, irrelevance. Since the NSL approval is not part of the requested relief, Marathon contends that any related testimony or exhibits are irrelevant and material under 1915-4-17A. You don't have to agree with each statement I make. I'll ask you at the end. Number 3, that Powderhorn's administrative NSL applications were protested by Marathon in October of 2025 and subsequently canceled on November 29, 2025, because Powderhorn failed to resolve the objections within 30 days. Okay. And number 4, basically you're saying it's improper bootstrapping. Marathon is asserting here that when an administrative application is rejected due to an objection, the proper procedure is to file a new application for a hearing, not to bootstrap it into an existing pooling case without proper notice.
Correct.
Good. Now, the response in opposition from Powderhorn. Powderhorn argues that I should deny the motion because the evidence is essential for the division to evaluate the proposed development plan. Number 1, necessity for evaluation. Powderhorn contends that the division cannot meaningfully assess a compulsory pooling application without understanding the engineering rationale and specific locations of the proposed wells. Broad admissibility. Under 1915-4-17A and MAC, examiners have broad discretion to admit relevant evidence. Lack of prejudice. Marathon has known about the proposed NSL since August of 2025. Powderhorn notes that of the 17 noticed parties, Marathon is the sole remaining objector, suggesting the motion is a delay tactic. 2 more issues. Administrative efficiency. Powderhorn requested the division adjudicate the NSL within the current proceeding to avoid duplicative, costly, inefficient second hearing involving the same parties and evidence. And the last one, even if the division decides the NSLs must be pursued separately, Powderhorn argues the evidence remains relevant to show the completeness, reasonableness, and good faith of the development plan. Did I capture that?
Yes, sir.
Oh, good. All right. You know, the way I look at administrative hearings is that they're due process hearings, and due process is flexible so that it gives me some way to craft some sort of middle ground here. I understand the argument. I understand the argument in opposition. Seems like I have several paths forward. Number one, I could conditionally admit the evidence for the limited purpose of evaluating the reasonableness and good faith of the development plan. The exhibits would be part of the record for the pooling case, but the division would not grant the actual NSL approval in this proceeding. That way, Powderhorn gets to explain their engineering logic to the examiner now, while Marathon preserves its right to a separate formal hearing on the specific NSL technicalities later. 2, this is sort of a de facto consolidation. The compromise. The division could allow Powderhorn to verbally amend its application to include the NSL relief, provided it can prove that all 17 effective parties received notice that was substantially equivalent to the hearing notice. If I find that this previous notice was sufficient to satisfy due process, we could hear both matters and avoid a duplicative proceeding. Finally, since Marathon relied on the XTO Apache precedent, which suggests a rejected administrative application requires a brand new filing for a hearing, I could hear the pooling evidence now, but stay the final order until Powderhorn formally refiles its NSL application. This at least keeps the case moving forward without violating the technical requirement that the specific NSL relief must be included in the application. Finally, the parties could reach a middle ground by agreeing on certain technical facts while disagreeing on the procedural law. Marathon could withdraw its objection to the admissibility of the evidence if Powderhorn stipulates that the evidence cannot be used as the legal basis for an immediate NSL order. So, let me ask you a question, Mr. Holliday. When it comes to giving me the evidence I need to show that all 17 affected parties received notice that was substantially equivalent to the hearing notice about the NSL, what do you say?
If I were to rank our priorities on this, the first would be to allow the evidence in so that we can assess the development plan. Because seeking these offsets in the Purple Sage Wolf Camp is a common course business. Every operator does it. It's fully expected that Powderhorn would in its development plan.
And by you're saying offset, you mean non-standard location?
Yes, the non-standard locations. Yes, sir. Shrinking the heel toe from 330 to 100 feet. So that would be priority number one. We would prefer, rather than have a duplicative hearing, that we could hear it all at one time. We have the same parties, same evidence, same notices, same counsel probably, and we're already here. So
is that an answer to the question I just asked?
Yes, sir.
I wasn't sure.
Okay, so yes, sir, our main priority would be to get the evidence in, and we would.
That's not what I asked
Okay.
you, though. I don't want you to rank the options right now. What I'm asking you is for number 2 to be even an option. I need to hear from you on how all 17 parties were given notice about this NSL.
Okay, I believe they are because they're the same parties in the case. I would need to compare the NSL notice to the hearing notice to ensure that there weren't maybe some offset operators to the NSL locations.
That answer doesn't really say that you know. So, and I need to make a decision now.
Sure.
Okay, so without knowing that, I'm going to take option 2 off the table. I do find the evidence relevant and material. So I'm going to let the evidence in, but I'm not going to, the division will not make a ruling on the NSL as part of today's contested hearing. Did you have something to say, Ms. Smith?
Yes, I want to make a couple of
Go ahead.
points. Number one, so Powderhorn confuses the issue here. The Marathon is not arguing at all. The Powderhorn is not entitled to present its proposed and complete plan.
Okay.
It can do that. And if they want to discuss longer lateral lengths, they can do that. They can do that because they have their C-102s included in their hearing packet, which includes their first and last take points, which are at a non-standard location. They're two separate issues. The longer lateral lengths, they can discuss that through their C-102s. The NSL, the canceled administrative applications for non-standard well location, that is not relevant and material because it's not a part of their application for
Which
hearing.
exhibit is that?
It was which one? The C-102s or the canceled administrative applications? So
What
that's
exhibit is
the
that?
A18 and I think A19, what I included or outlined in my objection. So you give me
So
one.
hold on, Ms. Vance. Mr. Holliday, would you please tell me what are the exhibits that I just listed a minute ago? What is exhibit A9?
A19, sorry, and A18.
Okay, well, I'm not asking you about A19, Ms. Vance, so please hold on.
Sure.
Mr. Holliday, what is exhibit A9?
A9 is our pooled party list and commitment status. There's a reference to the NSL, like a not even complete sentence in there.
Okay, so based on my ruling, you can remove that reference to the NSL, right?
We could remove the reference to the NSL from A9, yes.
What I'm asking you. Okay, so that cures that A9, based on my ruling, that I still find some of this evidence to be relevant and material. So let me continue with Mr. Holliday first.
And
What is A18, Mr. Holliday?
A18 is a summary of the non-standard location rationale that Powderhorn would like to present. And A19, I'll just skip ahead, is our sample notice letter that was sent out on October 22nd.
So Mr. Holliday, if I have ruled that since your pre-hearing statement did not, I'm accepting the argument made by Ms. Vance that because the pre-hearing statement did not contain a request for an NSL and that you need to proceed on that separately, do you still need A18?
I think we do need A18 to
Why?
tell the complete story of the development plan.
Okay, and Ms. Vance?
it's included with their C-102s. It has their first and last take point. If they want to discuss that through their direct testimony, they can. And further, I do want to point out that this is prejudicial to Marathon. This was not included in their original application. As you pointed out, there was a period of time that they were through the administrative process to resolve this issue with Marathon. That ended at it was November 29th, 2025. And so they've had 3 months if they wanted to file a new application or an amended application and do new notice and include this as a part of their affirmative case and requested relief. They have not done that. We got no heads up from their counsel that they were going to include this as a part of their affirmative case and also request that they have that they include the approval for this as a part of their affirmative case. And so and it wasn't included in their pre-hearing statement. So then Marathon is prejudiced. We are not allowed to we're not in a position where we were able to make that a part of our affirmative case. So I would request that this is removed from their that the testimony and exhibits be removed. And if they want to file, I know you've got some other suggestions about how to keep the case moving forward, but at least for us here today, this should not be a part of the case at all.
I've already ruled on exhibit A9 and that they're going to remove the reference to an NSL in A9. So I can't see how that would prejudice you with exhibit A9.
I'm talking about the A18, A19, and then the testimony of Mr. Maka's testimony.
Okay, so what I'm going to do with A18, A19, and paragraph 30 of Mr. Maka's statement is, let's wait until you're presenting your case, because I'm not going to tell you how to present your case. And I don't think it's right for an opposing party to say what you need and what you don't need. I understand their objection. I found in favor to an extent in their favor, but I still feel like you need to be able to make a full and fair case. and give us the information that shows what I said before. That I'm going to go back to what I said before. That I'm going to admit the evidence for the limited purpose of evaluating the reasonableness and good faith of your development plan, as long as it doesn't prejudice the other party, because I do understand Ms. Vance's argument as well, that, you know, you had all this time to do this, and all of a sudden they're seeing this. That's understandable. There's no way around that. So, so you'll make your individual, when we get these exhibits, you'll make your argument as to each exhibit, not A9, because I've already ruled about A9, but A18 and A19, and then that paragraph of Mr. Maka's. You'll make your argument at that time when we can see it. Because I have to figure out what part of those exhibits, if any, goes to the bigger picture and what part is prejudicial and unfair, because I agree with that part of the argument. So, so that will be my ruling, that I'm going to admit. So we're not proceeding on the NSL today. So in that respect, I'm granting the motion. However, Mr. Holliday needs to be able to make a full and fair case. And if part of that evidence goes toward the reasonableness and the good faith of the development plan, then I want to hear it, and the division wants to hear it. So that's how I want to proceed on that preliminary matter. Now, what I want to do next is I want to discuss my reading of the pre-hearing statements and the issues in contention. This is for both myself, the parties, anyone who's listening, and for Mr. Fordyce, who I've already discussed this with. So I see that there are really I really see four issues here between Marathon and Powderhorn that we need to take evidence and make a decision based on. Number one, control of overlapping acreage. And of course, this is the central conflict. It involves the north half of irregular section 2, which both companies include in their proposed spacing units. I'm going to say Marathon's position first. Marathon claims that it owns or controls 100% of the working interest in this specific acreage through a 1976 JOA. They argue that under our precedent, the operator with the majority interest in the overlapping area should prevail. Powderhorn, on the other hand, seeks to pool all uncommitted interests within a larger 959.6 acre unit that includes Section 2. They argue that that OCD precedent orders R14140, R23869 allow the division to pool acreage already subject to a JOA into a larger spacing unit. Mr. Holliday, did I outline in the bare bones way issue of controlling overlapping acreage?
Yes, sir, as to the issues.
Of course. Ms. Vance?
I'll take it.
Mr. Rankin?
I think it's a fair overview of the representative arguments. Yeah.
And that's all I'm doing here.
Yeah.
Just trying to give a very broad 30,000 feet perspective so that everyone feels like they're oriented here. At least I do. Number two, risk of stranded acreage versus efficient development. The parties disagree on which plan better protects correlative rights and prevents waste. First, I'll give Powderhorn's concern. Powderhorn alleges that Marathon's plan, which is limited to the north half of Section 2, will strand the northeast quarter of Section 3. They argue that their 1.5 mile laterals provide a more comprehensive development of the Wolf Camp formation. Marathon argues that Powderhorn's asynchronous drilling plan will cause parent-child degradation, and that Powderhorn's approach forfeits economies of scale that Marathon's co-development of Wolf Camp benches would capture. Mr. Holliday?
That's sufficient. Yes, sir.
Mr. Rankin?
I think that's an accurate capture of the arguments.
We're halfway there. Three, Operator qualifications and readiness. Marathon raises several challenges regarding Powderhorn's capability to execute its proposed plan. They raise the following issues: operational track record. Marathon points out that Powderhorn is a new operator in New Mexico with no history of drilling horizontal wells in the state. Marathon conversely notes it already operates existing wells in the area. And infrastructure and permitting. Marathon claims it has approved applications for permit to drill. Firm commitments for takeaway, water, gas, and oil, and a pre-approved state communitization agreement. Marathon asserts Powderhorn lacks APDs and has not secured takeaway for oil and gas. Mr. Rankin?
That's a fair summary of the readiness arguments that we presented.
And last, good faith negotiations. Again, Marathon contends that Powderhorn did not engage in good faith negotiations before seeking compulsory pooling. This is a standard requirement for the division to grant a pooling order. You don't have to agree with that. It's pretty simple.
Mr. Examiner, if I may
Yes.
circle back to point number one.
Yes.
We only actually have one proposed development plan in front of the division today.
Okay.
That's the Powderhorn plan that's seeking to pool the acreage within the Super Hornet unit. Marathon's objecting on the rationale that they will self-develop, but there's no plan before the division for that.
I thought that was because Marathon's plan, I thought they had a 320 acre, 0.32 acre spacing unit plan that they didn't need because they have voluntary commitment.
Okay, that's correct. We're tracking on that issue. Yes, sir.
No, I would strenuously disagree that actually there are two development plans firmly in front of. Yeah, there are two plans. We did, however, only one pooling application is before the division. We do have a contradictory contradictory development plan that involves fully developing the north half of section 2 Wolf Camp acreage. So that's what Mr. Holiday is referring to. Yes, it's a plan to self-develop. It is a development plan. There are APDs that have been issued, and the Marathon is ready and willing and able to go forward with this drilling plan.
Oh, thank you. So I think next, let's deal with exhibits. Let's try to get as many admitted through stipulation as we can. So, Mr. Holiday, what exhibits have you submitted for this hearing?
We have submitted 2 packets of exhibits, our original exhibits, and a much smaller rebuttal packet.
Perfect. How have you labeled your exhibits?
We've labeled A as our land exhibits, and then that's A1 through 19. And this is on page 2 of our original exhibit package. We have a page numbered index.
Okay.
B, we have our geology. So we have 7 original exhibits in our geology. And then for C, we have reservoir, where there are 6 exhibits. And for D, it's legal. Those are my exhibits, and that there are 4 there.
Okay. I didn't catch how many reservoir exhibits you have.
6.
6. All right. So let me just repeat this because this will be very important. You have your land exhibits marked as exhibits A and then A1 through 19.
Correct.
Okay, good. Your geology exhibits are marked as B and then B1 through B7.
Correct.
Your reservoir engineering exhibits are C and then C1 through C6.
Correct.
All right. Your legal exhibits are D and D1 through D4.
Yes, sir.
And then you have rebuttal exhibits, but let's wait for just a moment on the rebuttals. I want to ask you a few questions. Let's see. I wrote this down somewhere. Hold on a second. One moment. I show your, here we go. Okay, I show Travis Mocka is your landman.
Yes.
Leonard Wood is your geologist.
Correct.
Brendan Tippin, reservoir engineer.
Yes, sir.
All right, and then obviously you. Okay, now, I recognize some of these names. Have all 3 of your expert witnesses been admitted before this division as experts in their fields?
Yes, they have.
Okay, very good. All right, so that's excellent. Now, your rebuttal exhibits, how have you marked those?
So we've marked those in a similar fashion on page 2 of the rebuttal packet. We've just continued the numbering.
Yeah,
So A is still land. And then we seek to admit exhibits A20 through 25.
okay, fine,
For B, our geology, we have one additional exhibit, B8.
okay.
And for reservoir exhibit C, we have 2 additional, that would be C7 and C8.
All right, now. I don't know who, Mr. Rankin? Okay, good. All right, so from now on, I'm just calling on you. All right, fine. You'll let me know when you get tired and you want Ms. Vance to take over. All right, so Mr. Rankin, have you had a chance to review all these exhibits?
I have.
Okay, great. Are you willing to admit any of them through a stipulation?
I'm happy to admit all the exhibits, including A18 with the caveat that we have an outstanding objection to it being admitted on the grounds for the motion. And so I won't further make any arguments on that, but just with the caveat that A18 is remains subject to our motion to exclude.
What about A19?
It doesn't really serve any purpose because since the division's already ruled that it's not going to
Okay,
rule on the NSL application, grant that relief, it doesn't really serve any purpose. So it's extraneous, I think.
okay, fine. I have it here. So basically then, what I'm understanding from you is you have no objection to admitting all of the exhibits that we just talked about, including the rebuttal exhibits, with the exception of A18.
Correct.
Okay, good. And I think there's also a paragraph in A2, wasn't there, A30?
That's correct. And I think, again, it's almost irrelevant because the division is not going to rule to grant that relief.
Okay, all right, well, I'm just being proactive here. Okay, fine. So, Mr. Holliday, your exhibits are all admitted to evidence with the exceptions that we just spoke about.
Thank you.
Okay, now let's go to Marathon. Can you walk me through what I just asked Mr. Holliday?
Sure. Thank you, Mr. Hearing Examiner. Marathon has submitted a set of direct testimony exhibits marked A, B, and C. A is the self-affirmed statement of Ms. Shelley Klingler, landman. She's previously been qualified already in land matters. Attached are her exhibits A1 through A8.
Mr. Rankin, does that include a self-affirmed statement that's generally marked as Exhibit A? So is it?
Correct. So A is a separate
Right.
exhibit and then A1 through A8.
Okay, got it. What's next?
Same process
Yep.
for Mr. Preston Dupree, he's a geologist. He has not previously testified. His exhibits are B, which is a self-affirmed statement, and then B1 through B5, which include his resume. Okay. And then finally, exhibit C, which is the self-affirmed statement of Dr. Umekwe. He's a engineer, reservoir engineer, and he has not previously testified before the division. And attached is his sole exhibit for undirect is his resume, C1.
Thank you. No rebuttal exhibits?
We filed rebuttal exhibits. Wouldn't miss the opportunity. And those are exhibits numbered Marathon rebuttal exhibits 1 through 9.
All right, so they don't necessarily track the original witnesses. They're just 1 through 9.
Correct.
Okay, that's fine. Okay, Mr. Holliday, now it's your turn to give reason.
We have no objection to the exhibits or the rebuttal exhibits.
Sure. Thank you, sir. So I want to mention, Mr. Aragon, all the exhibits from both parties have been admitted except A18, that's Powderhorn, and paragraph 30 of Powderhorn's exhibit A. Do you copy?
Noted. Thank you.
Thank you. All right, so we have now to decide who's going first. I would think it would be you, Mr. Holliday. Are you good with that?
Yes, sir.
You are good with that. Okay, and is there any objection, Mr.?
No, Mr. Hearing Officer, in fact, we have conferred on that exact issue. And if it's okay with you, I might, and with Mr. Holliday, represent to you what we discussed and agreed, if that's okay, if you agree.
Great.
So in the past, I think we've taken different approaches with contested hearings. And here, I do think it's most efficient if the presenting party were to present each of their witnesses, go from direct right into rebuttal,
Agreed.
go into cross, and then available for division examination.
Agreed.
Now, the only other twist is that one of our witnesses who's remote is not available tomorrow. So we've asked,
Remember you mentioned
we've asked that he be permitted to go out of order
by all means.
so that he,
Today before we close.
thank you very much.
Yeah. Yes. And what is the name of that witness?
Dr. Umekwe, the reservoir engineer.
What country is he from? Oh,
Nigeria.
yes, perfect. Okay. We will get you in today, sir. Okay, Mr. Holliday, I don't know if you feel necessary, but if you do, 1 or 2 minute opening statement.
Yes, sir. I'll get, excuse me, I'll get through this as briefly as I can. All right. So my name is Ben Holliday. I represent the applicant in this case, Powderhorn Operating. And this case concerns whether the division should approve a 960 acre horizontal spacing unit covering section 2 and the east half of section 3 and township 24 south, range 26 east for Wolf Camp development. Powderhorn's evidence is going to show that Powderhorn's proposed development plan is a real engineered and executable plan that will efficiently develop the entire 960 acres. It will prevent waste and protect the correlative rights of all owners in the spacing unit that include the state of New Mexico. By contrast, Marathon asked the division to deny Powderhorn's application based on a 50-year-old joint operating agreement that was written for vertical wells that has never been used to develop the Wolfcamp Formation and contains no provisions for horizontal development across multiple sections. So the division has already addressed this precise situation as we've discussed in the Fierro case, order number R23869 last year, where the division confirmed that it has the authority to approve pooling over the objection of an operator who's relying on a legacy vertical era JOA when the division finds that it's necessary to ensure the efficient development and to protect correlative rights. So we believe the facts in this case track those in Fierro and are at least as compelling, if not more so. Powderhorn started with its development plan in July of 2025 and it acquired in July of 25 and proposed development within 7 days. In that time period, Powderhorn has secured over 78% of the working interest commitment to its development plan. It has obtained, like Marathon, pre-approval for the required state communitization agreement. Powderhorn has staked its drilling location. They have secured water contracts. They have prepared a fully engineered development plan that targets the Wolfcamp A and which has provisions for later infill development of the Wolfcamp B. If granted an order, Powderhorn intends to spud as well in September of 2026. Okay, so again, to sum up Marathon's argument, Marathon objects primarily on the argument that a 76 joint operating agreement covering the north half of section 2 only gives it exclusive control over development, at least as to the north half and as affects this case, the entire proposed Super Hornet spacing unit. But our evidence is going to show 3 things. One, as I mentioned, that JOA has never been used to develop Wolfcamp Formation in the nearly 50 years that it's existed. Second, the largest interest owner subject to that agreement, non-operated working interest owner subject to that joint operating agreement, Kaiser Francis, has already signed a superseding JOA, horizontal JOA with Powderhorn, agreeing to participate in Powderhorn's development of the full 960. And finally, Marathon's own proposed alternative does not develop all of the acreage that Powderhorn seeks to pool, particularly state minerals in section 3. So if Powderhorn's application is denied, those acres risk being stranded with no division imposed timeline requiring development of the north half of section 2. So we're going to present 3 witnesses, as we mentioned earlier. First, you're going to hear from Mr. Maka, that's Powderhorn's land representative. And so Mr. Maka is going to go through the company's efforts to negotiate with Marathon over the past 7 months, the commitments that Powderhorn has obtained from other working interest owners in the unit, proposed unit, and the concrete steps that Powderhorn has taken to prepare for development in this area. We're next going to hear from Mr. Wood, or next in Powderhorn's order anyway. Mr. Wood will explain the geological continuity of the Wolfcamp across the proposed unit, and we will discuss the regional, everyone's favorite topic, regional stress orientation that supports Powderhorn's east-west well design. And then finally, we're going to hear from Mr. Tippin, Powderhorn's reservoir engineer. Mr. Tippin will explain why Powderhorn's 1.5 mile development plan is more efficient and better suited to develop the full unit than the 1 mile alternative proposed by Marathon, and why Marathon's claims about mandatory co-development of the Wolfcamp A and B are not supported by the data. So at the end of the hearing, our evidence will show 3 things. One, Powderhorn has presented the division with real plans to drill wells and has taken concrete steps to execute on those plans. This plan is going to efficiently develop the entire 960 acres, including state minerals that would otherwise, at least at a minimum, be at risk of going undeveloped. And finally, that approving Powderhorn's application will prevent waste and protect the correlative rights of all parties as is required. So for those reasons, Powderhorn requests the division approve the requested pooling order. Thank you.
Mr. Rankin, would you like to make your opening statement now?
I'd like to reserve my opening to see how things shake out until we present our case in chief.
Very good. Yeah.
I would, though, if you don't mind, Mr. Examiner, I might just raise a potentially brewing evidentiary dispute that was brought to my attention from the opening. I will just point out that in their case in chief, Powderhorn has made the argument that the northeast quarter of Section 3 will be stranded by Marathon's development. And I just heard from the opening statement that they intend to present testimony on well orientation. That argument is integral to the stranding argument. Okay, whether the orientation, what the orientation of the well should be, or if there's a preferred orientation. That should have been part of their case in chief. Okay, because if they're going to argue it's stranded in northeast quarter, it was required to be made in their case in chief that there was a preferred well orientation. And they didn't make it in their case in chief, nor did they make it in the rebuttal. So at this point, I'm going to say, if it comes up, that I want to just apprise the division that that's going to be an objection, because number one, it was necessary to be made in their case in chief. They made the affirmative argument that the northeast quarter was going to be stranded. The only way for it to be stranded is if they could argue that there was a laydown only preferred orientation, and they didn't make it in their case in chief, and they haven't made it in the rebuttal. And so it's now far delayed to make that argument at this late date.
You can make your objection at the time.
Thank you.
That's your right. Okay, so you're reserving your opening. That's fine. How many, I'd like to get all the witnesses sworn in at the same time. I see, would all the witnesses, besides Ms. Hatley, come on up to the witness stand over here? You're not a witness, are you, Ms. Hatley? I didn't think so.
Maybe someday.
That'll be the day, huh, Ms. Hatley? Okay, 1, 2, 3. Okay. How many are from Powderhorn? 2, perfect. And you're from Marathon, very good. And my understanding is that there's one more each that must be virtual. Okay, can we get those witnesses? I see Mr. Umeki, all right. And then there should be one more virtual. I see now, thank you. Okay, very good. I see you, Mr. Wood. Mr. Pascal, would you please say your name properly?
Yeah, my name is Madwabuchi Pascal Omekwe.
Gee whiz, I didn't even hear. Would you mind if I call you Mr. Pascal? Does that bother you?
Not at all.
Okay,
That's
good.
fine.
Because I was hoping you would clarify how you say your last name, but I didn't even hear you say it, which is not good for me. All right, so would everyone please raise their right hands? Very good. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, perfect. I heard from everyone. Okay, you can lower your hands. Thank you. Now, for the people here in the room, will you turn on that microphone? There's a button on the right. It'll turn green. Would you state and spell your name for the record and tell me if you have been admitted as an expert before this division, tell me what expertise that's in. If you haven't, please tell me and stay there.
Preston Dupree. I have not been admitted as an expert witness.
But you seek to be admitted as an expert witness in what field?
Petroleum geology.
Petroleum geology. And are you with Marathon?
Yes, I am.
I thought so. Okay, Mr. Dupree. Okay, we'll get to your qualifications in a moment, so don't go back to your seat yet. Go right ahead, ma'am.
Good morning, Mr. Examiner. Shelley Klingler, Shelley Klingler. and I have been admitted for petroleum land matters.
And I recognize you just from recently in the last, yes, I thought so. And are you with Marathon?
Yes, sir.
You are, okay. And you said Land Matters, Ms. Klingler. Thank you. Okay, go ahead.
My name is Brendan Tippin. I have not been admitted before the commission before, but I'm seeking to be an expert in reservoir engineering.
And you're with Powderhorn?
Correct.
I thought so. So,
Misspoke.
okay, that's okay. So you won't be going anywhere quick soon. And then Mr. Maka, I recognize you.
Yes, Travis Maka, TravisMacha, and I've been admitted in land.
I know you have. So Mr. Maka and Ms. Klingler, please have a seat. Let's deal with your one at a time. Please have a seat. Okay, now, are you Mr. Tippin?
Dupree.
Dupree. You're Mr. Tippin?
Yes.
You're very good. Mr. Dupree. Tell me about your education toward the field of geology.
Yes, sir. I did my bachelor's of science degree in geology at Texas A&M University.
What year?
Graduated in 2019.
Oh, okay.
And then I did my master's of science in geology at TCU, graduating in 2023.
What's TCU?
Texas Christian University. Yes, sir.
Okay, thank you. And then what work have you done? What experience do you have toward petroleum geology?
Yes, sir. After my graduation at A&M, I was a mudlogger, so I worked in various areas across New Mexico and Texas, working for various operators, collecting mud samples, doing logs per client request. During my time at Texas Christian University, I was working also full time at Finley Resources. They are now called Uinta Wax, working out of the Uinta Basin. Following that, I was working at U.S. Energy Development Corporation, doing wellbore deals and ballot evaluations across the Permian Basin. And then in 2023, I came over to ConocoPhillips and I've been here ever since.
Oh, you're with ConocoPhillips?
And Marathon subsidiary.
It's the same company or under the same umbrella?
Yes.
Oh, okay. I didn't know that. You never told me that, Miss Hatley.
Subsidiary.
I didn't know that. Thank you. What is your title at ConocoPhillips?
Currently just geologist.
Geologist.
Yes, sir.
And what are your current duties now?
I am currently the development geologist across portions of Eddy County, responsible for development projects from conception to spud. Also in charge of leading third-party contractors by geosteering. That pretty much sums up what I do.
What part of your job requires that you interpret the geology underground?
On a daily basis, based off the development projects that we have, such as the project we're referring to today. Just different development projects that we have. Don't want to speak too specifically about that, but across Eddy County, I'm evaluating different projects that we are doing internally.
Okay. And you said something about Uinta. Is that in Utah?
Yes.
Okay.
Green River Formation.
Yeah, I thought so. Okay. Okay, so from here on in, you're qualified before this division as an expert in petroleum geology. Mr. Tippin, would you do the same thing? Education first and experience, throw in some dates. Tell me how your education and your experience lend toward reservoir engineering.
Yes, sir. So my name is Brendan Tippin. I went to the University of Texas and studied petroleum engineering. And have a bachelor's degree in petroleum engineering. After Texas,
when did you earn it?
2012 to 2016.
Thank you.
In 2016, I started with Piedra Resources, a Permian-based oil and gas operator. I've worked with Piedra Resources for 8 years until 2024. I started as a reservoir engineer, ended as their lead reservoir engineer, and oversaw acquisitions, planning, and development of our oil and gas resources.
What does a reservoir engineer do?
We evaluate deals on the front end, evaluate acreage and block together positions. Once we have a position, we do detailed planning of how we responsibly develop that position. And then we work with our operations teams to responsibly develop the position.
Okay, all right. And so you're with who now?
I'm with Powderhorn Engineer Powderhorn Energy. I'm their Director of Engineering. I've been there since 2024. And I currently oversee all of the A&D engineering work related to acquiring leasehold. I oversee trades and in work blocking up as it relates to engineering. And then I'm also looking forward in the development and planning of our assets.
Okay. All right, thank you. From here on in, you're recognized as an expert in reservoir engineering. Now, let me go to Mr. Wood because your picture is nice and large at the bottom of my screen. You've been, would you state and spell your name and tell me what expertise you've been admitted before this division?
Yes, Mr. Hearing Examiner, Leonard Wood, Leonard, last name Wood, Wood. I have been admitted as a witness in the field of geology before.
In geology, okay. And you're with Marathon?
I am with Powderhorn Energy Partners. Sir.
You're with Powderhorn, thank you. All right, thank you. And finally, Mr. Pascal?
Yes, I've not, again, I'm Pascal Umekwe. I've not been admitted as an expert witness here before. My background is, like was mentioned earlier, I was raised in West Africa, and my bachelor's degrees was in petroleum engineering. I completed that in 2009, and I moved to the US for my graduate studies, still in petroleum engineering. So I got my master's degree in petroleum engineering in the University of Alaska in Fairbanks. After that, I worked in the Bakken in the field with Baker Hughes, doing MWD, LWD, so logging while drilling stuff. Then after that, I joined ConocoPhillips as a development petroleum engineer, doing development work, so essentially assessing the subsurface and drilling opportunities in the Kuparuk field. So I did that for a little while. Then later on, I went off to work for the state of Alaska, where I worked as a petroleum economist. At the same time, I was doing my graduate studies in economics as well. I worked with the state of Alaska for about 6 to 7 years, where I held roles in petroleum economics. I worked as a commercial analyst. And in 2022, I joined ConocoPhillips here in Midland, working the Eddy County development. So doing essentially subsurface evaluations leading up to the drilling of wells, building an economic case for wells, as well as trades, helping us to core up acreage as well as divest or acquire new areas to develop.
So, Mr. Umekwe, would you spell your name for the record, please?
So Umekwe, my last name is Umekwe, and I go by Pascal, which is my middle name.
Would you spell it, please?
Pascal.
Okay, Mr. Umekwe, what does a petroleum engineer do?
A petroleum engineer works alongside geologists and other functions to allow us assess the viability of projects, subsurface projects, leading up to the production of hydrocarbons. And in this specific case, a petroleum engineer would be evaluating the viability of different scenarios for development, looking at existing data on similar developments and trying to assess, what development style might be best, to ensure that the right returns are generated for projects.
How is that different from a reservoir engineer?
So a petroleum engineer is a broad discipline. What I described earlier maybe speaks more to kind of a reservoir engineer and what the reservoir engineer does. But the petroleum engineer interfaces with, again, production engineering, drilling engineering, and different forms of engineering. But at the end of the day, the goal for the petroleum engineer or the reservoir engineer is to premise projects that allow developers of that project to get adequate returns.
Okay, perfect. Thank you, sir. So from here on in, you're recognized as an expert in petroleum engineering by this division. And what time do you need to testify by?
Anytime today, I think is great.
Okay. And what time zone are you in?
I'm in the Midland office here, CST, so Central Time.
Okay, very good. You're an hour ahead of us. Okay, that's what I wanted to know. Thank you very much. Okay, Mr. Holliday, would you like to, one thing for both parties. Please understand, as you can tell, both Mr. Fordyce and I have spent considerable time reviewing your exhibits, reading your testimony. You do not need to repeat the same things verbatim as in the exhibits. Please have your witnesses summarize their testimony. In plain language would be nice for those of us who are not, petroleum engineers. And also present your rebuttal case at the same time that you're presenting your case in chief for each witness. So would you like to call Mr. Maka first?
Yes, Powderhorn first calls Travis Maka.
And Mr. Holliday, are you going to be, these are your exhibits, so are you going to be showing them on the screen? I mean, you don't have to, you certainly don't have to, but if you want to, you can screen share. I'm not telling you how to present.
No, I know. I don't know that. Adam, would you mind driving the exhibits? Yeah. I'm not sure if I'm set up for. Oh, do you? Okay. Nice try. Would you give us a second to confer while we try to get the exhibits up?
I don't need the exhibits.
Okay.
I'm only saying if you feel the need to put an exhibit on the screen, I'm just saying you have the capability of screen sharing. That's all I'm saying.
I think we're okay to proceed without them. And if we do need one, we'll address it at that point.
And we'll deal with it then. Yes.
Yes, sir. Okay. Just a few matters for the record. Mr. Maka, could you please state your name and position with Powderhorn?
Travis Maka, I'm the Vice President of Land.
And so to refresh the division's memory, how long have you been a petroleum landman?
It's probably about 8 to 9 years at this point.
Okay. And before this, you were the land manager for New Mexico at Permian Resources, right?
That is correct.
In that role, you're responsible for all the New Mexico land operations for Permian Resources, which is a publicly traded company.
That is correct.
Right. All right. And you prepared the self-affirmed statement and the exhibits, or at least at your direction.
That is correct.
Right. Let's sort of start from the top. When did Powderhorn first acquire its interest in the Super Hornet development area?
That would have been, we closed on July 23rd of 2025.
And what did you do immediately after acquiring that acreage?
The next day, obviously at that point, we're a young operator, so we started looking around. We wanted to acquire more acreage. We wanted to work with whoever was in the prospective development area. So we did go ahead and reach out to ConocoPhillips the next day on July 24th. We sent them an email kind of giving them notice that we will be proposing wells. We will be giving them carry offers, and we'll be looking to engage them on negotiations going forward.
Okay. And when did you first propose wells to the various working interest owners?
They're dated July 30th. I believe they got put in the mail on July 31st.
Okay. And those well proposals include AFEs and the normal.
That's correct.
So after you sent the well proposals, did you attempt to negotiate voluntary agreement with Marathon?
Yeah, on July 31st, we did go ahead and send an email with our first carry offer to ConocoPhillips. They did acknowledge receipt of that carry offer. Over the course of August, Conoco reached out one time and asked about our lateral length confirmation. I believe that was August 13th. They asked of why we were not including the west half of section 3 in our plan development, which why we're not doing that is because there's an existing Wolfcamp well in west half 3 operated by Permian Resources. We sat around, waited for them to kind of respond and digest our carry offer. And then we did not re-engage until September 5th.
Okay, you mentioned waiting on responses. These first initial emails that you reached out to ConocoPhillips to try to get a meeting, something like that. Did you ever receive any response whatsoever from Conoco?
Yeah, so on the July 24th email, we did not receive a response, and subsequent to that in July, I did send another email to the non-op supervisor at the time, and I did not receive a response. I was requesting a meeting.
Good. And you mentioned in your testimony that Powderhorn initially had applied for the October docket for the Super Hornet case, but you held it to November. Why did you do that?
We had the capability of applying for the October docket. We did not apply for the October docket. When we reached back out on September 5th, we inquired of another meeting. We kind of gave a status update. That email was also not responded to. At that point, on September 11th, I reached out to another Conoco landman and asked what was going on, like why were we not receiving responses? But I did tell him that we are looking forward to negotiating with them because we do want to broaden our footprint. So we did go ahead and say, hey, in order to have some good faith negotiations, we did go ahead and kick this to the November 13th docket rather than the October docket. At that point, Conoco did start engaging a little bit more.
And so that was to give Conoco more time to engage with this, correct?
That and every other party, right?
Right. Okay. So let's talk about, there was a proposed trade and that broke down. And I think we're going to have to talk a lot about it today, but Ms. Klingler's testimony alleges that Powderhorn broadly did not engaged in bad faith negotiations by offering acreage that it did not own. Can you describe that from your perspective?
Yeah, so just in reference to the trade, obviously throughout 2025, we did kind of give multiple offers, including a letter of intent with our letterhead and kind of detailed the offer structure and everything. But the trade itself, how that started was on December 19th. We received an inbound from a third party group that told us, hey, we have some acreage offset Conoco. We just leased it. Would you guys be interested in acquiring it, doing a deal, whatever you guys want to do? And we didn't reach back out immediately. We told them we would look at it. Candidly, there wasn't a big interest internally originally, but they reached back out again in January. And on January 12th, we did poke Conoco and we said, hey, we have this acreage, and upon verbal agreement with third party, they allowed us to negotiate with their acreage with ConocoPhillips specifically. So we did say, hey, Conoco, would you like to acquire this acreage? We need some quick feedback, obviously knowing that we didn't know what other parties that they were shopping to or anything like that. So at that point, we asked for quick feedback. We got a response and a formal trade offer from Conoco on February 2nd.
And it was Conoco that first proposed structuring the transaction as a trade, correct?
I would say, I would characterize that they were the ones that formally proposed the trade first. Everything we said was subject to evaluation.
And in your experience as a landman, are these sorts of third-party transactions common course of business?
Yes, we did many transactions like this at Permian Resources with me specifically.
And how long was this third-party acreage under discussion with Marathon before the deal fell through?
So they reached back out on February 2nd. Immediately upon learning they were interested, we reached back out to the third party to see if they were interested. I think at the time they were on vacation, so we did not receive an immediate response. And then on February 6th, they responded that there was an alternative route that they had to pursue. And at that point in time, our CEO did inform Conoco that the trade was no longer viable.
So a period of about 4 or 5 days.
4 days.
4 days, okay. So after this, did Marathon, did they terminate negotiations with Powderhorn? Did they end at that point?
No, we continued to discuss carry options.
And how long was it before Conoco finally informed you that it wasn't seeking any sort of mutual agreement or deal?
So we started discussing carry options, if I remember correct, on February 10th. That was the next Tuesday. And then multiple phone calls since then, between then and February 20th is when they formally terminated negotiations.
So during that time period and before they terminated negotiations with you, Conoco had already sent its 1 mile proposals to Kaiser Francis. Is that correct?
That is correct.
Okay. Did Conoco or Marathon, did they send those same well proposals to Powderhorn at that time?
No,
And Powderhorn is a party also to the JOA through another working interest. Is that correct?
that is correct.
So at any point during this 7 months from July all the way to February, did Powderhorn ever take this deal off the table or any sort of termination of negotiations?
No, we remained before we proposed the wells to February 20th that we wanted to do a deal.
All right, I want to turn to the steps you guys have taken to prepare for development. Can you just summarize what Powderhorn has done to get ready to drill these Super Hornet wells?
So on the land side, as mentioned, one of my primary jobs is to not only acquire acreage, but it is to put units together. So from July of last year, we started acquiring acreage. We started the compulsory pooling process. We started working with surveying groups. We did do the pre-approval for the New Mexico communitization agreement. And we did get our water contract in place. We have kicked off active negotiations for oil and gas takeaway, and we have staked the wells.
Okay. Do you think that acquiring APDs would be a time constraint in this project?
No, I don't.
And what's your anticipated spud date?
As of right now, we're looking around September 2026, but anywhere in Q3, Q4.
Okay, and that is at least partially because you have a term assignment with an expiration date, is that correct?
That is correct.
So if Powderhorn cannot commence operations before that date, what happens to your interest?
We stand at risk of expiring and losing it.
All right, so let's talk about the working interest and the unit. What is Powderhorn's working interest in the proposed 960?
Across the entire 960, about 34% working interest.
And if we were to lump in the total working interest that's committed to your plan, what number does that come to?
It's about 78%.
Okay, so do you have an interest in every track, either owned or committed?
Yes.
All right. And if we look just to the north half of section 2, that's the main subject of this debate today. What is Powderhorn's committed net acreage in the north half of section 2 that is subject to the 1976 JOA?
I think our title versus Conoco's title was a little bit different between a couple percent, but we're looking at around 160 acres, so roughly 50%. I think they're pegging it closer to 45%.
So fair to say 45 to 50%.
Yes.
Okay. And then that's Kaiser Francis. So the Kaiser Francis, who's the largest non-operated working interest owner under that JOA, let's just call it 47% split the baby. They did sign a superseding JOA with Powderhorn. Is that correct?
That is correct.
And at this time, is ConocoPhillips the sole party objecting to your application?
That's correct.
So let's look at that JOA for a second, or at least let's just talk about it. Marathon's objection to your application, it's based on this JOA from 1976. Are you familiar with that JOA?
Yes, I've reviewed it.
And that's a Form 610, which at that time was designed for vertical well operations, right?
Yeah, it's a 1956 form.
1956. So to your knowledge, does that JOA even contemplate horizontal development?
No.
And then to your knowledge, that in 1976, was horizontal development occurring in the northern Delaware Basin in the approximate area of this project?
Given my land background, I can't give you definitive, but I do not believe so.
Okay. And how many wells have been drilled under that JOA in its 50-year history?
One.
One well. Is that the initial well?
That was the initial well.
And that's a vertical well?
It's a vertical well drilled, I believe, in 1976. The OCD record says spud in 1974, but I'd assume that's incorrect.
Okay, so nothing in 50 years. And so that means no wolf camp's ever been drilled under that JOA.
That's correct.
No horizontal well of any kind.
Correct.
Now, despite this JOA, Conoco or Marathon originally proposed a 1.5 mile development plan. Is that correct?
Yes,
But then they rescinded it and replaced it with the 1 mile plan we're talking about today. Is that right?
that is correct.
All right, Mr. Maka, are you familiar with the Fierro case in order number 23869?
Yes, I am.
And in that case, the division approved compulsory pooling over the objection of an operator that claimed 100% working interest control under a legacy JOA. Is that a fair summary?
That is correct.
Do Do you think the facts in this case are substantially similar to those in the Fiero case?
I would agree with that, yes.
And you're also familiar with order number R14140, the Matador case,
I'm
number
not
15.
as intimate with that one, but yes.
Okay. And that's the case that the Fiero order cites as precedent for his decision. Is that correct?
Correct.
Okay, let's talk about some of that overlapping acreage. The JOA, as we discussed, covers the north half of section 2, and that's about 1/3 of the acreage within the proposed Super Hornet spacing unit. Is that correct?
That is correct.
Is that similar in size to the JOA overlap that was under consideration in Fiero?
Yes, a minority share.
Now, one of the issues that we've brought up, or that's been brought up in this case, we certainly didn't bring it up, is operator experience. Your experience, Powderhorn's experience as a team. You guys haven't drilled a well yet. So they argued that you haven't previously drilled a horizontal well in New Mexico. Is that correct?
That is correct.
Okay. But you guys have been part of horizontal development, each in your own respective backgrounds. Is that correct?
That is correct.
How many wells do you think you assisted with in your time at Permian Resources?
So on the operator experience exhibit that we cite, we did kind of label about 1,000 plus between our group, and that did come from an exact kind of tenure of time between us and New Mexico. So between all of us, about 1,000. I don't remember me specifically, but it was considerable.
Do you recall approximately how many rigs were under your direction from a land perspective?
Upwards of 7.
Upwards of 7. You talk about a couple of units in your testimony, the Bat Bomb and the War Pigeon units. In terms of operator experience, why are those units relevant to our hearing today?
So those 2 units are 1 mile directly to the east. I'm not going to speak to geology or reservoir engineering, but closeology, they're very similar. So Conoco and those units had the vast majority of the working interest, and they did entrust an operator that had never drilled a well in the state of New Mexico to take over operations of those units. So characterizing us as inexperienced and to be disqualified for that same reason seems wrong.
Okay, so there's recent precedent from Marathon for entrusting its acreage to an operator who has not drilled a well in New Mexico. Is that fair summary?
That's fair.
Okay. And you guys you mentioned you tried to have a meeting. There was a meeting scheduled on the 4th. It got canceled. And that was going to be a technical meeting so that you guys could present your experience and plans to Conoco. Is that correct?
Yeah, we were going to bring our entire technical team as well as kind of our kind of development strategy and everything to that February 4th meeting.
So if we get into technical a little bit, as a landman, is there anything you wanted to give to Marathon's parent-child well degradation arguments?
No, I'm going to refer to that for reservoir.
You're not a reservoir engineer, correct?
No.
Right. So Mr. Rankin raised a couple things. Well, first, let's back up and talk about NSL permits. Does Powderhorn intend to seek NSL permits, allowing it to amend the 330 offset rule?
We intend to.
Okay. And is that, in your experience, a normal administrative procedure pursued by most operators developing the well count?
Yes.
Okay. All right. I want to turn to the northeast quarter of section 3 and the potential stranding issue. Mr. Rankin raised an issue with potential stranding of the northeast quarter, or we raised it, but he had some concerns about it. Do you think you could clarify Powderhorn's argument with regard to the northeast quarter section 3?
Yeah, I'm not going to make a orientation argument there, but what I will say is that in the east half of section 3 and the south half of section 2, there are owners that exclude Marathon. They do not own in those areas. And prior to the 1 mile well proposal, Powderhorn and Avant agreed via letter agreement on how to develop that 1.5 miles. And at this point, it's an agreement that's been signed. So that northeast quarter of section 3 would be excluded from that development.
So fair to say, if your application is denied, you're going to be contractually prohibited from developing the northeast quarter
As it sits, correct?
as it stands now. And if, okay, think of that. And who owns the mineral interest under section 3?
State of New Mexico owns 100% of east half of 3 and all of 2.
And Marathon, they dismissed their competing pooling applications. We covered that, correct?
That's correct.
So they're not asking the division to approve any alternative development plan. What they're asking the division to do is deny yours and leave the north half of section 2 entirely subject to their private JOA. Is that and correct? With no division oversight as to the timing of development.
That's correct.
Okay. And there's no party under that mechanism outside of the contractual rights under the GOA. There's no division enforceable mechanism to compel development of that acreage. Good. So in your opinion, or is it your opinion that Powderhorn's application, if approved, will prevent waste and protect correlative rights of all interest owners, including the state of New Mexico?
Yes.
Just a couple more questions, and I'll pass the witness. So based on your experience, and just to sum up, your familiarity with this acreage, the steps you've taken over the past 7-8 months, do you have an opinion as to whether the division should approve your application in case 25610?
Yeah. Like I say, I think that we've made a pretty legally complete argument here. Everything's being developed in a prudent manner. The NSL applications obviously we're not going to be discussing today, but we'll come back for those. Yeah, I'm very confident in this polling strategy.
Okay. Is there anything else in your testimony or your exhibits that you would like to cover that we haven't covered yet?
I don't think so.
Okay, thanks. I pass the witness.
Cross examine.
Thank you, Mr. Hearing Officer. Good afternoon, Mr. Maka. How are you today?
Good. How are you?
It's unusual for us to be on the other side of this procedure, but nevertheless, here we are. Starting off, I'm going to ask you about well proposals. So you mentioned in your opening summary that Powderhorn sent out well proposals back in July, at the very end of July, 2025. And I'm going to go ahead and share my screen because it's just easier to walk through the exhibits when we can talk through them directly. So I think this exhibit A16 is your well proposal that went out, correct, for these wells that issued today?
That's correct.
Okay, and they were issued, it was signed by Mason Maxwell, who's a landman, correct?
That is correct.
And what's his role with the company?
He's the landman.
And so what was his role in the proposal of these wells?
Me and Mason collaborate on this stuff together. We built the well proposals side by side.
Okay. So was he involved? He was also involved in the negotiations over this proposal?
That is correct.
Okay. And the well proposal includes 8 wells, correct?
That is correct.
And 4 wells in I'm going to call it the Upper Wolfcamp, the Wolfcamp XY sand. Is that correct?
That's, I think, generally correct. Yeah.
And then there's 4 additional wells for the Wolfcamp. Powderhorn's calling it the Wolfcamp B. Is that correct as well?
Yes, that's correct.
But in the application for pooling, Powderhorn has only identified 4 initial wells as part of its application, correct?
That is correct.
And those are the Wolfcamp XY wells, correct?
That is correct.
And because those are the only 4 wells in the pooling application, Powderhorn would be limited to drilling those 4 wells initially and completing those wells before it could drill any additional wells as part of the unit, correct?
We would be following OCD standard, yes.
Okay, so each of those all 4 wells would have to be drilled and completed before you could come back and complete or even drill or propose any subsequent well, correct?
Yeah, I believe that we would be technically allowed to drill them, but not propose them until after completion of the first initial wells.
Okay.
Not that we would do that, but just nuance. Yeah.
Okay. Now, is Powderhorn committed to drilling all 4 of its proposed Wolfcamp B wells, the subsequent wells?
I I'm going to defer to our technical guys, but yes, that is the current plan.
Okay. Now just for purposes of clarification, in your statement, I'll go paragraph 10 of your statement. I've got it highlighted here in purple. You state that Powderhorn proposes to fully develop the Wolf Camp with its 4 1.5 mile wells. Is that a correct understanding of your statement there?
I guess that could be construed as Wolf Camp A. I think the intent of that statement would be to fully develop as per the order received.
But you're not saying that those 4 wells will fully develop the entire Wolf Camp, correct? You're saying that it's going to fully develop that bench. Is that fair?
That is a fair statement.
Okay. And that's why you need to come back and drill the Wolf Camp B, right?
At least, yeah.
Okay. Now on the just a couple of smaller issues I'm going to walk through with you. In one of your land charts where you show the working interest, and you show the working interest breakdown, this is one where I think is the overview for the whole spacing unit. You identify the company PBX LLC as owning approximately 35% in a tract in the south half of the proposed spacing unit, correct?
That is correct.
Okay. And you state here that you identify them on title, but that they're not, and they're listed as an uncommitted interest, correct?
Yes.
But they have not been provided notice of the hearing, is that correct?
I believe they were provided notice. I'm not sure, but I've corresponded with the director over there greatly on this exact issue of the title. I think it's probably just a weird title issue that we need to clean up.
So whether or not they were provided notice, it would be of record in the exhibits provided by Powderhorn to the division, correct?
That should be
Okay.
the case.
And so rather than spending time to do that, I mean, the record speaks for itself. Agree?
Agreed.
Okay. But nevertheless, they're an uncommitted party as we sit here today, correct?
Correct. And we are not seeking to pull them.
Okay. So, but as you sit here today, you can't tell me whether or not they were given notice of the application or the pooling, correct?
Like I say, I'm not sure, but they were recipients of the initial well proposals and the initial application. I'm pretty certain of that.
So just to be clear, you did send them well proposals back in July 2025?
That's correct.
Okay. Did you have any follow-up discussions with them about their position?
Yes, so they were one that we are in negotiations with. We originally just were hoping to just get them committed to a JOA because they're historically not sellers. I think that they're pretty active, kind of similar to us, and they just want to put dollars to work. And so we negotiated with them for a brief time. They did indicate they were going to transact and sell. They did sell to Avant. So the intent in all of the communications that I've had with PBEX is that they've sold 100% of their interest in the Super Hornet unit to Avant. Our title, like I say, per that asterisk, still showed them with 14 acres in that southwest of the southeast corner of section 2 that is not included in Marathon's unit. So that's why I wanted to be open and transparent, included on this exhibit.
When did they sell their interest to Avant?
Oh, I don't think they closed until maybe January, but I think that negotiation was more complete around October.
Okay. So if there was any record title conveyed or filed with the county, it wouldn't have happened until after they closed, right?
That would be correct.
Okay. And basically, as you sit here today, you think it was most likely in the timeframe of January 2026?
I believe so, but I don't have perfect recollection of that.
But as of the time that Powderhorn filed its pooling application, PBX was the owner of that interest?
When we filed originally in September, I believe for the November docket, yes.
Okay. I'm going to move over to the topic of Powderhorn as and its experience as an entity. Just to clarify, again, Powderhorn does not currently operate any wells in New Mexico, agree?
That is correct.
And Powderhorn has not drilled any vertical wells in New Mexico, agree?
That is correct.
And Powderhorn has not drilled any horizontal wells in New Mexico, agree?
That is correct.
And Powderhorn doesn't have an in-house drilling team currently, agree?
That we have in-house petroleum engineers. We do not have an in-house drilling team, if that is defined.
Okay. So you agree with me based on your own understanding that Powderhorn does not itself have an in-house drilling team, agree?
Agreed.
Okay. And do you have an in-house drilling engineer who would oversee any drilling?
I'll defer to my engineer, but I don't believe there's a degree for it for drilling engineering. Petroleum engineering degree does cover drilling.
Say that again. I'm sorry, I
A
missed it.
petroleum engineering degree would cover drilling.
But I mean, I guess my question is, does Powderhorn have someone assigned who is in charge of, responsible for overseeing its drilling operations?
We're all responsible of numerous things, so I would say yes.
Okay, so there is one individual at Powderhorn who is assigned the obligation to coordinate and oversee when drilling occurs.
I would say we will have to be coordinating with our contractors, but yes, they will be overseeing the drilling activities.
Who is that?
I would point to Brendan Tippin
To answer that question or to tell me who that?
to answer that question.
Okay. So turning to Brendan's, Mr. Tippin's, rebuttal testimony. Paragraph 7, I've highlighted the language here in his rebuttal. He says that Powderhorn has, he's responding to Marathon's objection or concerns that Powderhorn had not yet identified a reliable tested outside drilling contractor. And then he goes on to say they're uncertain about the basis for the assertion. And he goes, then he states that we've been talking and exploring options with drilling contractors since May of 2025. He goes on to say, as it relates to this unit, we have been working with a contractor that has drilled wells in the last year within 2 miles of the unit. Are you familiar with his testimony of his on rebuttal?
Yes.
Okay, so just to be clear, are you aware of, as of this time, and again, you can tell me to talk to Mr. Tippin, but whether Powderhorn has identified an outside drilling contractor to drill these wells?
So as per his testimony, there is a company that we've been consulting with that drilled the bat bomb and ward pigeon units that Conoco farmed out to another operator.
Okay. And when you say working with, are they under some sort of contract or agreement? Are they designated to drill these wells if and when?
I'll defer to Brendan on the specifics of any agreement because I'm not in the technical conversations right there.
Okay. And are you aware whether during the discussions or negotiations with Marathon, Powderhorn has ever disclosed who it was working with to do this work?
We had that fully prepared and laid out for the February 4th meeting.
Okay, but during the informal discussions, when these things were discussed, are you aware of any time at which Powderhorn informed
They never
Marathon of
asked.
who the drilling contractor was going to be or who you're
No,
working with?
Sorry,
Yeah.
no, they did never ask.
Gentlemen, this is the reporter. I apologize for interrupting, but if you could wait to respond to questions until the question is done.
Sometimes I throw a pause in there and as Travis knows. So I apologize. I try to get it all out. Okay, on the drilling contractor issue. During the informal discussions, to your knowledge, you're not aware of Marathon asking that question of anybody at Powderhorn. Is that correct?
I'm not aware.
Okay. Now, during your summary of your case, Mr. Holliday asked you about, your team's experience drilling and operating. And I think the way he phrased the question was that each under their own respective backgrounds have had experience drilling wells separately, correct?
That's correct.
But in terms of a team, has Powderhorn, because it's never drilled a horizontal well as an entity, has it ever drilled a well as a team?
As an entity, no.
And has Powderhorn ever worked with this drilling contractor that you referenced, that you're working with currently? Has it ever worked with that drilling contractor as a team?
I would defer to the definition of working with. We've never drilled a well with them.
Okay. So Powderhorn as an entity and as a team has never drilled a well with this outside contractor, correct?
Correct.
So you mentioned a contractor that ConocoPhillips engaged with that has no drilling experience in New Mexico. Do you recall that testimony?
Sorry, can you repeat?
Yeah, that ConocoPhillips had engaged with a drilling company that has never drilled a well in New Mexico. Do you recall that testimony of yours?
It wasn't a drilling company, it was a separate operator,
Separate operator.
similar to Powder.
Do you know yourself whether people at Marathon and ConocoPhillips have had experience working with that operator as a team in Texas?
I'm not aware.
So you don't know whether they've drilled multiple wells or what the extent of their experience drilling wells with this operator in Texas has been, correct?
I don't have direct knowledge.
Does Powderhorn have any experience with this outside contractor drilling any wells in Texas?
No.
In any other place?
No.
Okay. I think I understand you to basically defer all discussions about parent-child testimony to Mr. Tippin, correct?
Yeah.
Okay. On your direct testimony, you testify about ConocoPhillips activity in the area. And again, just to be clear, the operator here that's contesting Powderhorn's case is Marathon, correct?
Correct. I do define Conoco COP in my original testimony as being Marathon Oil.
Okay. And that's because Marathon is now a wholly owned subsidiary of ConocoPhillips, correct?
Correct.
And are you aware when that transaction took place?
I don't remember
5 years ago, 8 years ago, more recently than that?
more recently than that.
Okay. So let's look at your testimony in paragraph 12. I'm sorry, in paragraph 18, sorry. You talk here about, and I've highlighted a provision or a statement here that ConocoPhillips has been primarily inactive in terms of operations in the area for the last 8 years. So you're not aware when, prior to ConocoPhillips acquisition of Marathon and this acreage, did ConocoPhillips own any acreage in this area?
I'm not aware.
Okay. And so you don't have in your mind exactly how recently it was that ConocoPhillips actually acquired Marathon interests?
No. Yeah.
Okay. And so you're not sitting here today telling me that ConocoPhillips owned this acreage and this contested acreage or the offsetting acreage prior to its acquisition of Marathon, correct?
No, I'm not testifying to that.
Okay. Now, I'm going to go to one of your exhibits on the same topic here. And again, you're talking about ConocoPhillips's activity in this acreage. And I think the point of this slide is to make the point that in your view, rather than developing this acreage, ConocoPhillips is instead divesting it. Is that the point of this slide?
Yeah, I would say that's fair.
And you give 3 examples and you've labeled them A, B, and C. And my question to you is, what does divesting or divestment mean to you?
It means bequeathing operatorship in this scenario.
Okay, in this scenario. So you're not talking about selling or trading out or leaving the property, correct?
No, and just for clarification, A was a term assignment, for Marathon, B and C were development agreements, which seem to be characterized as farm out agreements.
And your knowledge of those, the terms of those agreements or how involved ConocoPhillips or Marathon was in those agreements is solely based on public records, correct?
That is correct.
So you have no idea how involved ConocoPhillips was in the development of that acreage in terms of planning, assessing, evaluating, targeting, any of that?
No, I'm looking at public record.
Okay, so all you know is what's in the public record and nothing that went behind the scenes or how actually involved ConocoPhillips or Marathon was in those acres, correct?
Correct.
Okay. And based on your definition of divestment, meaning like you would get another operator to drill for you, isn't that what Powderhorn is considering to do here in its proposed acreage?
No, we would be the cost bearing interest owner being the operator. That's what I mean. Bearing the cost, not a drilling contractor.
And again, you don't know exactly what the relationship is behind the scenes between ConocoPhillips and the operator drilling this acreage, other than what's reported in public record, correct?
Correct.
Okay. But you agree with me that as to the A, B, and C on your slide here, ConocoPhillips did not sell out its interest, agree?
No, not 100%.
Did it trade out its interest?
Not that I can see. No.
I'm going to ask you about this question of stranding the acreage in the northeast quarter of section 3. In paragraph 11 and then throughout your exhibits, you make the assertion that the acreage will be stranded if Marathon's development goes forward, correct?
Correct.
And we learned today for the first time, because you don't say it in your direct testimony, and you don't say it in your rebuttal testimony, that the reason for that potential stranding is because Powderhorn made a contractual agreement with another entity, correct?
That is correct.
So it has nothing to do with geology, it has nothing to do with engineering, it has everything to do with Powderhorn's business decision with a third party, correct?
I will defer to geology on orientation, and anything like that, but yes, that agreement was negotiated predominantly prior to Marathon's 1 mile proposals.
And, okay. So that, now, you're aware, you're familiar with the direct testimony that was filed by Powderhorn in this case, correct?
Yes,
And you reviewed the testimony of your geologist?
for the most part, yeah.
Okay, are you aware of your geologist making any statements about the preferred orientation in this acreage in his direct testimony?
I can't speak directly.
Okay.
I'm not that intimate with it.
Okay, but to your knowledge, did he make a statement affirmatively one way or the other about a preferred orientation?
Not to my knowledge. I don't know.
But for the agreement with Avant that you announced to us today, is there anything to your knowledge preventing Powderhorn from developing a stand-up well in the east half of section 3?
I mean, at that point, it would be a contested hearing with Avant and contractual issues and I think lawsuit. I don't know, like that's an issue.
So there's outside contractual issues that complicate Powderhorn's ability to do that. And then my question to you is, but for that agreement, to your knowledge, is there anything preventing Powderhorn from doing a stand-up well in the east half of section 3?
If we are talking about a hypothetical scenario where that agreement never existed, I would be comfortable with my ability to form that unit.
You'd be what?
I would be comfortable being able to form that unit north-south.
Right, because when you look around, including in your exhibit A8, there's a variety of well orientations immediately offsetting, stand up, lay down. And in fact, in your testimony, you identify Mewburn as an offsetting operator. And in your exhibit, you show that they have future planned lay down and stand up wells that they plan to develop simultaneously. Agree?
That is correct.
Okay. And in your rebuttal statement, Mr. Mucker, you don't raise the stranding argument again, do you?
I'm not sure. I don't remember.
In your rebuttal?
I don't think that there was anything to rebut at that point.
Okay, so you didn't raise it in your rebuttal statement that we filed, but you did raise it in your summary today, bringing forth new information about the contract or agreement that Powderhorn had made with Avant, correct? When was that agreement made with Avant?
It was negotiated. Oh, I have to look at the timeline. I feel like the last week has been long. We signed it, I think the 2nd of March. So we negotiated the week before.
Got it. So that was part of the deal that resolved your conflict with Avant, especially as to the south half, correct?
Yes.
Okay. Now, is that an agreement that was involving land title? Was it filed of record, or will it be filed of record?
There will be things filed of record later potentially, but it does contain confidentiality language. Yeah.
Well, that was my next question. So it has confidential provisions. Okay, correct. Now, I may come back to the NSL issue later, but I'm going to skip it for now. I'm going to move into the ownership control topic. I'm going to go back to your working interest breakdown. This is the first one. I think you've got two different breakdowns. I'm going to address this first one. Mr. Hearing Officer?
Yes.
It just occurred to me that I didn't actually keep track of when I started. But I think probably now might be a good time to take a short break if we were to
I think
take.
it's a great idea. 5 minutes?
5 minutes will do.
Okay, we're off the record. Well, we probably have some questions. Oh, that's. We do get to ask questions.
Somebody forgot.
No, we don't forget those kind of things. Are you ready to go back on the record, Mr. Rankin? Yes. Mr. Maka?
Yep.
Okay, it is 3:19 PM. We're back on the record, and Mr. Rankin, go right ahead.
Okay, Mr. Maka, I'm going to ask you a couple of questions now about the working interests that you reflect in your exhibits and testimony. I'm going to start off at your exhibit A10 as part of your direct case. And I'm going to ask you just to confirm that the ownership breakdown that you reflect here on a tract and unit basis on this exhibit is for Powderhorn's entire proposed spacing unit. Agree?
Yes,
And it's based on record title ownership, not contractual interests. Agree?
that is correct. Leasehold,
In other words, it was what was filed in the county records, right?
correct.
Now you're showing that Powderhorn owns 5.01 net acres in one of the tracts, correct?
That is correct.
And that's tract 2 on your ownership tract on the next page, correct? Which is green.
Yep, correct.
Okay. And that's Powderhorn's only working interest ownership in the north half of section 2, correct?
Correct.
Correct.
That is our own working interest. Correct.
Okay. And that was acquired in September 2025 from Vatex, correct?
Vortex, I believe, but yes.
Vatex is how, okay, Vatex. And that interest originally derived from the Price family. Is that correct?
That is correct.
And that price interest is committed to Marathon's JOA in the north half of section 2, agree?
When we acquired it, yes, they didn't have a copy, but after receiving a copy of the JOA, I agree that it was committed.
And it remains committed, correct?
Correct.
Okay. Now, you said that you didn't have a copy of the JOA at the time you acquired that interest, is that correct?
That is correct.
And when I say you, I mean Powderhorn.
Correct.
Okay. Were you aware at the time that you acquired the interest that it was subject to a JOA?
There was a JOA as referenced in assignments. It didn't say how big it was or what it covered, but yes, there was a JOA.
So you knew at the time of the purchase that it was subject to a JOA. You just didn't have the JOA document in front of you, correct?
Correct.
Okay. So you were aware at the time you acquired it that it was going to be a committed interest. It was going to be already subject to a JOA. Agree?
Some sort, yes.
Okay. But you didn't know at the time that it was Marathon's JOA. Is that what you're telling me?
Not really, no, I didn't. I knew Marathon operated the well. I mean, the automatic assumption is that yes, there was a Marathon JOA, but I didn't know what lands it covered, if it was different spacing or what it was.
Okay, so at the time you acquired it, though, you agree that you knew it was a Marathon JOA. You just didn't know what acreage was being
I
covered.
think I would agree with that, yeah.
Okay. And again, that was acquired back in September of 2025, agree?
Yes.
Okay. Now, you have another breakout of ownership interest on your exhibit A11, and this is a little bit different. And I think it has a title apples to apples, but it's not quite apples to apples because you're including still portions of section 3 in your breakout, correct?
Yes.
And when I think of apples to apples, if I were comparing Marathon's development plan to Powderhorn's development plan, I would have excluded section 3. Would you understand why I'm saying that?
Yeah, I think my logic was I just didn't see the option of stranding the northeast of 3.
Okay, because at the time you filed these exhibits, you would have already made that contractual agreement with Avant where you were bound to include that section 3 as part of any horizontal development, correct?
Correct.
Okay. All right, now I'm going to talk to you a little bit more about this Vatex. I'm going to call it Vatex. I'm going to have a hard time. Is it Vatex? Is that what you said?
I'm not sure, but yeah.
Vatex, Vatex. Okay, I'm going to ask you a little more about the Vatex term assignment. I think you've got an exhibit that outlines much of the sort of publicly available details of that term assignment. Is that fair to say?
Yes.
So exhibit A12 is a summary of this term assignment deal that Powderhorn made with Vatex, correct?
That is correct.
And just for purposes of everyone's edification, tell me if you agree that generally a term assignment requires the assignee to perfect some obligation to earn the interest in the term assignment. Is that a fair representation?
That's fair.
So as it stands right now, Vatex still owns the working interest, but Powderhorn has the right to perfect some action to earn whatever interest has been agreed to. Agree?
Agreed.
Okay. And there's a deadline on that, right?
Yes.
And the deadline is March 1st, 2027. Agree?
Agreed.
Okay. Now, you've outlined on this exhibit the territory or acreage that's included within that term assignment, correct?
Correct.
And that's the blue dash line? Is that correct?
Correct.
Okay. So as I understand it, based on the public records, that Powderhorn would need to drill one well and for it to be completed anywhere within the dash blue acreage. Is that correct?
I would say subject to the few clauses in that term assignment. I don't recall off the top of my head. But I'm not sure if we have to drill we have to drill our entire Super Hornet spacing unit as proposed to perfect the full term assignment.
Okay, so just to be clear, it could be anybody that drills a well, correct?
Correct.
It doesn't have to be Powderhorn that drills a well.
Correct.
But you're telling me that you believe that there are few clauses in the term assignment that would essentially, if you don't drill acreage, that acreage gets excluded, you don't earn it, correct?
I believe that's the case.
Okay, but you're not sure as you sit here?
We did it 6 months ago. I haven't reviewed it in depth since.
And as far as the public record is concerned, do you know if the publicly available documents include any reference to a pew clause, or if that would just be in the doc?
Be a memorandum.
Okay, and do you know if the memorandum includes any reference to a pew clause?
I don't believe so.
Okay, so looking at the public records, nobody would know whether or not there's an obligation to drill up the whole acreage, or if there's any pew clauses that govern, correct?
That's correct. Speaking from land, I would say that it's fairly implied with modern term assignments.
Okay. Is there any requirement for a certain length of well to be drilled under this agreement?
That I know for sure, which is a no.
Okay, so a 1 mile well would satisfy the term assignment, agree?
In theory, yes.
Well, I don't mean in theory, but based on your understanding of the agreement, would a 1 mile well satisfy the term assignment?
From my recollection, yes.
Okay. So would a single well drilled in the south half earn Powderhorn all the acreage in the south half of section 2?
I believe the spacing unit would have to encompass the entire south half if it was just one well, but yes.
Okay, and then a single well drilled in the north half would earn Powderhorn the entire north half, correct?
I believe that's the case.
And it could be a 1 well in the north half, is 1 mile well in the north half as well, correct?
I believe that's the case.
And so Marathon could drill a 1 mile well in the north half, and that would earn Powderhorn the north half acreage, and Powderhorn could drill a 1 mile well in the south half, and that would earn Powderhorn the south half acreage. Agree?
Agreed in concept.
Okay. Well, not just in concept, I'm asking, based on your understanding of the language, is there anything in the terms that would prevent that from coming to pass? If those wells are drilled as I described?
As described, no, you would be correct.
Now I want to go back to the acquisition of this Vatex interest. And at the time you acquired the interest, you being Powderhorn in September 2025, you testified that you knew that it was committed to a JOA operated by Marathon. You just didn't know the extent of the acreage, correct?
Correct.
So having acquired that acreage, you agree with me that those interests are subject to the terms of the JOA that Marathon operates, correct?
I would agree with that.
And that's that 1976 ancient document that didn't contemplate horizontal wells, right?
That'd be correct.
Okay. And you told me that you did review that JOA, correct?
Yes, in brief.
Okay. Now, during the time that you, and I understand from your earlier testimony that you worked with Mr. Maxwell to negotiate with Marathon during the course of negotiations, correct?
Correct.
During the course of those negotiations, did Powderhorn, either yourself or Mr. Maxwell, ever disclose to Marathon that you had acquired that Vatex interest in the north half of Section 2?
We told Conoco we were subject to a term assignment. I don't believe that we explicitly let them know.
Okay. So despite negotiating with them starting in September 2025, you never informed them that you had acquired a term assignment that was committed to their north half JOA, right?
That's correct. We didn't find it relevant.
Okay. Now, I understand you just recently reviewed or obtained the JOA. But as part of its conditions or requirements that you agree with me that Vatex and now Powderhorn are subject to, I'm going to read this provision, which is on page. Oh, the page number got cut off. Let me see. Must be page 13 of the JOA. It's provision 31-E, and I'm going to read it out loud. No assignment, transfer, or change of ownership in any form of any interest in any of the lands submitted to the performance of this agreement shall be binding upon operator until he has furnished a certified copy thereof and operator has agreed in writing to such assignment. Did I read that correctly?
That appears to be the case.
Yeah. And at any time up until this hearing, did Powderhorn or Vatex disclose to Marathon that they had acquired, that this transaction had occurred?
No, do you mind if I read this real fast?
Not at all. Take your time. So just kind of backing up here, and you can tell me if I'm wrong, but I believe as of middle of the summer, the price interest was still held by the prices. Is that fair to say?
That's fair.
And sometime subsequent to that date, it was then conveyed to Vatex, maybe July, August or so of 2025. Is that your understanding?
Yes.
And then shortly thereafter, between August and September, it was then conveyed to Powderhorn, correct?
Correct.
And to your knowledge, at any point during any of those transfers or transactions between Price and Powderhorn, did any party ever notify Marathon that those transactions occurred?
Not that I'm aware of.
Do you know if Marathon has agreed in writing to any of those assignments or transfers?
Not that I'm aware of.
Now, one of the things I understand from your rebuttal testimony is that, you make the point that Marathon did not provide its 1 mile well proposal under its JOA to Powderhorn until March 2nd, correct?
Correct.
And it had provided the other parties to the JOA that well proposal a few weeks earlier, correct?
Correct.
Okay. And do you know how it came about that Marathon then sent the well proposal on March 2nd to Powderhorn?
My assumption was that they were doing updated title.
Are you aware that the Friday before that Powderhorn's co-CEO notified Marathon for the first time that they acquired an interest in the north half of section 2, and that caused them to look up the interest?
I'm not aware of that explicit conversation. I didn't feel that the negotiations over the 7 months gave the impression that we didn't own an interest, but
So but you agree with me that once they learned that Powderhorn owned a committed interest under their JOA, that they immediately provided Powderhorn with a proposal for the 1 mile well, correct?
I would agree with that.
Okay. I'm going to talk a little bit about the relationship with Kaiser Francis. Oops, I did not mean to stop sharing. All right. Sorry, it's control bars in my way. I got there. Oh, I'm in the wrong exhibit packet. All right, so here on this page, this is again the apples to apples view, which is your exhibit A11. This working interest breakdown shows the Kaiser Francis is a working interest owner in the north half of section 2, correct?
Correct.
And I think if you were to compare your working interest representations of Kaiser Francis with what Marathon shows, I think they pretty much line up. Would you agree?
Yep.
Okay. And just in general, I think Mr. Halliday even said this during his questioning of you, it's about 140 net acres in the north half of 2, right?
Yes.
And now you show them being committed to your Powderhorn's JOA, agree?
Agreed.
And that's based on the fact that Kaiser Francis signed a JOA proposal proposed by Powderhorn, correct?
Correct.
But Kaiser Francis never rescinded, nor did it revoke its commitment to Marathon's JOA, did it?
Not that I'm aware of. I don't think that's an industry norm.
Okay. But you agree that their interest also remains committed, therefore, to Marathon's JOA, agree?
It's kind of a weird nuance, but I agree.
Okay. Now, you still show Kaiser Francis as being the owner of that working interest in the north half of section 2, agree?
Agree.
Okay. But Kaiser Francis made an agreement to trade its acreage reflected on this chart, or at least some of it, to Powderhorn in the event that Powderhorn prevails in this contested hearing, correct?
There are some other stipulations. They could retain their interest, but agree.
Okay. Now, that was a written agreement, correct?
Agree.
And was that also an agreement that was subject to a confidentiality provision?
Yes, I believe so.
Okay. So it wasn't filed of record, correct?
Correct.
Now, you show that Kaiser Francis is still owning in the north half because that deal is contingent on Powderhorn retaining or winning in this case, correct?
I still show them as this is because it's not filed of record.
Okay. So the deal's been signed, it's been executed, correct?
There's no assignment that's been filed or signed. That it's just a letter agreement. That's
The letter agreement, okay. But the terms of the letter agreement in general, correct me if I'm wrong, is that Kaiser Francis would trade all of its acreage in the north half of section 2 to Powderhorn in the event Powderhorn prevails in this contested hearing?
At a certain point, I am going to have to step in on the confidentiality language. I'm not sure how much I should be discussing, but the basic terms, what you're describing are correct.
Okay. So if Powderhorn prevails in this contested hearing and Kaiser Francis, under the terms of the agreement, transfers its ownership to Powderhorn, then Kaiser Francis will no longer own that interest in the north half of section 2, agree?
Agree.
Okay. And so its commitment to Powderhorn's JOA, through which it committed its acreage, to participate in the proposed development will no longer be of substance because it will no longer have any acreage in the north half of section 2. Agree?
Agree.
So in that potential hypothetical future, if Powderhorn prevails in this case and Powderhorn becomes operator of this acreage under its JOA, then Kaiser Francis will never actually be, you know, a partner in that JOA because it would have traded out its acreage, correct?
And like I say, there's other options for Kaiser. They can retain their interest in Super Hornet.
Okay. Have you had discussions directly with Kaiser Francis on this
Yes.
agreement? Do you know if they want to do they want to retain their interest if Powderhorn is the operator?
That has been a big conversation, yes.
Okay. Now, one thing I wanted to clear up a little bit, because again, it's nice to have a timeline, and I don't have a timeline. But one thing that caught my ear that I wanted to ask you about was I understand that that Powderhorn made a deal with Avant that essentially requires Powderhorn to drill horizontal wells, lay down horizontal wells across the northeast quarter of section 3, right? And that agreement, as I understand it, was in the timeframe of the beginning of March, correct, of this year?
Beginning of March, end of February.
Okay. And around the same time, March 2nd or March 3rd is when you received Marathon's well proposal for its 1 mile proposal, correct?
Correct.
But prior to that, in your discussions with Kaiser Francis, did you learn that Marathon, because Kaiser Francis is a partner under Marathon's JOA, did you learn from Kaiser Francis at any time prior to the deal with Avant that Marathon was proposing to drill a 1 mile well under its JOA?
Yes, and we learned that while they were still contemplating our carry, and that was being postured as being potentially accepted. So we weren't sure of the intent of any proposal to Kaiser without us. So we thought that might have been just a strange negotiation tactic for them or for us. We weren't sure.
Okay. So despite learning that fact from Kaiser Francis in advance of making that deal with Avant, Powderhorn nevertheless made that deal that locked in Powderhorn to a commitment to drill only lay down wells across the northeast quarter of section 3. Agree?
Yes, because we did not view the 1 mile as an actual viable plan for the area.
Okay. I want to get into the communications with Marathon in more detail. In paragraph 14 of your land statement. Oops. I'm sorry, paragraph 27 of your land statement. You talk about the negotiations and you refer to your communications log, okay? And when I go to your communications log, which I believe is exhibit. Sorry. Exhibit A15, right? That's your communications log?
Correct.
Okay, it indicates here that on February 20th is when ConocoPhillips informed Powderhorn that it was no longer pursuing a deal, correct?
Correct.
But you don't anywhere in your testimony or your exhibit here explain why, correct?
Correct.
Now, obviously, based on your communications log, there were extensive discussions going back months, correct?
Correct.
And I think you made the point that, you know, many of the discussions range from carry options to trade deals. And so it was a variety of different options that were put on the table, correct?
Correct.
Okay. In fact, you know, Powderhorn and Marathon had nearly come to an agreement in early February that had been negotiated between your team and Marathon's team, correct?
We never told them we approved of the deal. We told them it was pending evaluation.
Understood. And so it was always, I think, in fact, in the emails, you say there were some caveats that we needed a final approval, correct?
Correct.
And the caveats were about whether or not it was okay for a one-to-one trade, correct?
Just in general, trade evaluation.
Okay, so in the only, I mean, I'm just gonna say, I could pull up the emails, but in the emails, the only caveat that you provided to Marathon was whether or not your management was going to agree to one-to-one trade. Do you recall that?
That was on January 12th. And I said, it's pending eval.
Okay. So there were some discussions about evaluation, okay? But that never, up until the time that on February 6th, prior to February 6th, there was never a disclosure from Powderhorn that Powderhorn didn't actually own the acreage it was proposing to trade. Agree?
Agreed.
And in fact, based on the discussions with Marathon, Powderhorn put together a proposed letter of intent that included the acreage that was being discussed as a potential trade, correct?
Correct.
Okay. And based on the email exchanges with Marathon, would you agree with me that it was a potentially very attractive offer to Marathon because it proposed to allow them to extend some laterals in different acreage, correct?
And that is why we engaged with the third party.
Okay. Because you knew it would be attractive to Marathon, right?
Potentially.
Potentially attractive, right? Based on their public statements about wanting to extend laterals when possible, correct?
It was just logic that bolts on.
Okay. And so, and you agree with me that Marathon expressed its interest in this trade, correct?
So we asked for quick feedback citing about a week, and I think it took about 2 weeks for a response.
Now, in the interim, were you getting notifications that Marathon was elevating this, accelerating the evaluation, asking for a rushed review?
I don't recall rushed, but there was, I think, emails back and forth, including a meeting on January 15th. I think the carries were discussed in those as well.
Okay. But you're aware that Marathon was engaging its asset evaluation team and management to evaluate this proposed trade, right?
Which we wanted them to be doing.
Yeah, you expected that, right?
Correct.
Okay, so after you sent the letter of intent, and I don't have the exact date on it, but you agree with me that Marathon's landman told you that they were, quote, scrambling to evaluate for leadership, end quote, and that the Marathon asset team was, quote, pushing to move this forward, end quote, working to overcome management hurdles, end quote. Do you agree? Do you recall those general phrases in the emails back and forth?
General phrases.
Yeah. And that was based on the representation of the acreage proposed for the trade. Agree?
Agreed.
Okay. In fact, as part of those discussions, Marathon told you that they were looking at their contracts for water, gas, and oil as part of the potential agreement with Powderhorn. Agree?
Agreed.
Okay. And that way, Powderhorn could utilize the gas and oil commitments from a Marathon as part of Powderhorn's development. Agree?
Yes, in which we responded, we would take a look.
Okay. Now, again, at no time during any of these discussions did you disclose to Marathon that Powderhorn didn't actually own or have control or authority to offer this acreage actually for a trade, correct?
So we did have verbal agreement with the third party to negotiate with this tract. And Marathon is a competitor. We were not going to disclose our deal conversations with Conoco at that point in time.
Okay, and prior to the February 6th date on your date communications log, prior to that day, Marathon affirmatively asked to confirm whether Powderhorn actually owned the acreage. Do you recall that communication?
Yes.
And as I understand your testimony, that was in the midst of trying to confirm whether you would be able to own that acreage, correct?
Yeah. If you allow me to open end respond. So on February 2nd, like I say, they sent the trade proposal and formality. We likewise scrambled. We engaged the third party to make sure that they were okay with the terms in which were proposed. We prepared a letter of intent that explicitly called out the leases owned by said third party, provided that to Conoco. And we rushed the third party to get us an answer as soon as possible. On that same day, February 6th, they told us that they were going to have to pursue another option. And then a phone call was given to the COP landman stating such.
Okay. And that phone call came from Powderhorn's co-CEO, Mr. Jack Yates, correct?
Correct.
Okay. And that was on a follow-on to Ms. Klingler's repeated request to confirm whether or not Powderhorn actually owned that acreage as part of the trade. Agree?
Correct. Like I say, I recall several emails being sent that day. I'm pretty sure I was out of the office at that point in time because I remember seeing a lot of them coming in. So I deferred to Jack at that point in time. That's why he made the phone call.
Yeah. Okay. And now, would you agree with me that Powderhorn didn't initially disclose the fact that it didn't own that acreage to Marathon at any time prior to that date because it would have altered Marathon's willingness to negotiate on that trade? Would you
I
agree?
don't think that that's the case. We viewed it as irrelevant. It's acreage that we intended on delivering, whether it was coming from us or another party.
But having not disclosed that fact to Marathon, Marathon was unable in its calculations to discount the possibility of that deal not coming to fruition because there's a third party involved. Agree?
That's a fair statement.
Okay. And because they weren't able to discount that risk, it took them by surprise when they learned that, in fact, Powderhorn didn't own that. Would you agree based on the response?
Based on the response.
Yeah. Mr. Hearing Officer, I'll just take 2 minutes to make sure I may be complete with my question.
That's fine.
Okay.
Let's take 2 minutes.
Thank you.
Off the record.
Thank you, Mr. Hearing Officer. Are we back on the record? Okay. Just a couple of questions. We were just discussing, Mr. Hearing Officer, timing and making Dr. Umekwe available for his direct so we don't run out of time. I just have a couple, short topic to address with Mr. Maka, and then the question is whether we proceed with redirect and division questions, or whether we at this point then interject Dr. Umekwe so he can get done before the end of the day.
All right, it is 3:57. We're back on the record, and Mr. Rankin, we're going to finish with Mr. Maka before we take your witness, and so I urge you to be brief because I don't know how many questions Mr. Fordyce has, and I don't know how long the redirect is going to take. So please go ahead.
Yeah, appreciate it. Thank you, Mr. Maka. Just one line of questions here. You testified. We talked during our dialogue about the deal that Powderhorn made with Kaiser Francis. Do you recall that discussion with me?
Yes.
And you mentioned that there are some options for Kaiser Francis based on that deal, correct?
Yes.
And is one of those options for Powderhorn to carry all or portion of Kaiser Francis?
I can't get into the confidentiality at this point.
Let me ask you this then. In terms of the offers to Marathon, can you tell me whether or not you made an offer to carry Marathon, correct?
Yes.
Can you tell me that the offer that you made to Marathon did not match the offer that you made to Kaiser Francis in terms of a carry?
I can't disclose that.
So you can't tell me one way or the other whether the offer you made to Marathon at least matched the offer you made to Kaiser Francis?
The offer made to Marathon was extremely equitable, is what I can say, is within a very small degree, plus or minus, of Kaiser.
Okay. But it didn't match, agree?
It became within an extremely small margin of.
Very good. No further questions, Mr. Hearing Officer.
Mr. Fordyce?
Yeah, I have just a couple of clarifying questions for Mr. Maka. I have a question about Exhibit A10 on page 54. And actually, Mr. Rankin already touched on this a little bit. There's a question about PBX LLC transferring their interest to Avant. Mr. Maka, I guess it's your understanding that that was supposed to take place, but we're not 100% sure whether that's taken place or not, I guess.
Yes, so I think, yes, that is correct. So the PBEX interest that is shown on here, I think in all likelihood is just some title cleanup that needs to be done. PBEX did explicitly state that they intended 100% of their interest in Section 2 to be transferred to Avant. I've showed it here in good faith out of just transparency of title and what we are showing. That is the purpose of that.
So if you consider PBX uncommitted, why wouldn't you seek to pool them at this time until that transfer has taken place?
I've had a very good relationship with the people over there, and I'm not worried about that title cleanup. And if there is any necessity to either pull them or do a joinder via JOA, they've explicitly stated that they would work with us. So I didn't see the purpose.
Okay, thank you for that. I have a question about your Exhibit A9 on page 51. So as a follow-up to, basically who's being pooled, you have all of these overriding royalty interest and a couple of record title owners that you're, again, not seeking to pool.
Yes. Yeah, so
because you anticipate this COM agreement ratification is going to happen in the future.
Yes, so the record title for the state in Mexico, they require the actual signature. So we've had dialogue with X-Tex, Faulkner, I've worked with in the past especially on record title signatures. They're very easy to deal with. And the general stance that we took, and I usually generally take with Permian Resources and my landman experience in the past is I do like to just engage and get override royalty ratifications as we work through the process. If there's any need for additional pooling, or if no one or someone doesn't sign, we would come back and seek joinder via pooling at that point.
So one of the parties listed as a overriding royalty interest is Vatex, which we've already discussed some today, as being the party that Powderhorn has a term assignment from, correct?
That is correct.
I wonder if we could turn to page 167 for just a moment. On this notice list, I'm just wondering if you've had dealings with Vatex and you have a term assignment and so on and so forth. I'm wondering how it is that they didn't receive notice due to an incorrect address.
Yeah, it seems odd. That address, from my recollection, is correct. If it wasn't received, that would have been of no consequence, or at least of something that I wouldn't have been aware of. But Vatex, they're a group that we're close with on a personal level, that we're not concerned with.
Would you be able to provide an amended exhibit, I guess, or supplemental exhibit? That's a unit recapitulation for the proposed unit. The unit that you're proposing, not any other theoretical units, but the unit that Powderhorn's proposing, with all a summary of all the interest and again indicate the parties that Powderhorn is seeking to pool in this case?
Yes. Yes, I can.
I have a question about Exhibit A8 on page 49. So my question is, obviously the pooling case that we're discussing for the Wolfbone wells, or excuse me, the Wolfcamp wells. And this exhibit notes that, and you mentioned working with Avant to work a deal to drill Bone Springs wells in the planned unit depicted here in the south half of the proposed unit, correct?
That is correct.
During your negotiations, I'm curious, looking at this, does Powderhorn or Avant or another party propose to drill Bone Springs wells in the north half of this proposed unit?
Originally, Conoco did send proposals on a 1.5 mile basis to drill Bone Spring in their superseding JOA. Those were rescinded. We did send them counter proposals for the Bone Spring formation as well, to achieve standing, but both Conoco and Powderhorn viewed it as a secondary target that neither one of us wanted to pursue currently. Avant is more interested in it than we are.
Okay, I think maybe then to summarize, the parties that are involved, that would be a discussion for future, to sort out in the future, I guess.
Yes. So the parties to sort out in the future for the north half, for that northeast quarter of the Bone Spring, and the north half of the Bone Spring would again probably just be Powderhorn and Conoco.
Okay, thank you for that. I don't have any further questions for this witness.
Mr. Holliday?
Okay, I'd like to start out. We talked a lot about drilling contractors, Powderhorn's experience, those sorts of things. And the question was raised, who inside of Powderhorn would be responsible for drilling? Would that person be Patrick Walter, CEO of Powderhorn?
I think that he would be playing a heavy hand, yes.
And what is his background and qualification for planning drilling operations?
And he worked most recently before Powderhorn as the development manager for Taprock, serving in a very similar role.
So in that role, he would have worked with drilling contractors to accomplish the same sort of projects you're looking to do with the Super Hornet, correct?
I believe that is the case, yes.
Okay. So I'm going to try and share my screen. Yeah, danger. Uh-oh. Nope, that's my email. There we go. Now we're good. Okay, we're good. So I want to go to paragraph 10 of your self-affirmed statement for the original rebuttal. I mean, excuse me, the original exhibit packet. I'm sorry, paragraph 12. Hang on, I may be confusing rebuttals now. Anyway, there was a question raised in your testimony where you said to the effect, your plan will fully develop the Wolfcamp formation, correct?
Correct.
Would you like to amend that testimony or clarify in any way?
Yes, that would be the 4 initial Wolfcamp wells would be fully developing the Wolfcamp A bench within the Wolfcamp formation.
Okay. And, much has been made of the drilling contractors you guys plan to use or may plan to use. As it stands today, is it fair to say that the plan is to use the same drilling contractor that was used for the bat bomb and war pigeon units?
That is the plan, correct?
Okay. And that's a common thing to do for teams of your size, is to outsource that with internal oversight. Is that correct?
Yes, many private equities do the same thing.
Well, and publics as well, right?
Right. That's correct.
I think we heard from Mr. Dupree in his qualification testimony. He referenced some geosteering contractors. Is that correct?
That is correct.
And so if we go to rebuttal exhibit A24, teams. Okay, so if we go to exhibit A24, what is this exhibit?
These are just Conoco's AFEs for their 1 mile wells that they did propose.
And what does this exhibit tell us about Marathon's intended use of contractors?
The purpose is to show that large publics, including Marathon, do as well use contractors to drill wells.
So it's common, private, public companies, everyone uses contractors, correct?
Correct.
Okay, let's go back to this notice issue and PBEX and EGL and that sort of discussion. So I've pulled up here, this is exhibit, I believe it's D2, D1. And this is the list of notice parties. You see here, EGL, Finwing, and some other parties. Would you like to summarize who those parties are and why that's relevant?
Yes. So when Mr. Rankin did make note of the PBEX interest, maybe may or may not be receiving notice prior to our applications being filed. The of record owners of the quote PBEX interest were W. Wesley Perry, EGL, SES, Lairwick, Finwing, and I think that is it. All of those companies assigned into PBEX before assigning into Avant. So that is where the reference to PBEX comes from.
And EGL and PBEX are related companies. Is that fair to say?
Yes. I don't know if they still are, but EGL used to just be the operating entity for PBEX.
And Avant was noticed in this case, correct?
That is correct.
And is it your understanding that Marathon would have standing to raise a notice argument on behalf of a third party?
That is not my understanding.
Okay. And have any of these parties raised a notice argument other than Marathon?
No.
Okay. Real quick, because I know you're a landman and not a petroleum engineer. If we look at Marathon's rebuttal exhibit 6, that's it. Yeah, 6. Okay. If we look down in the bottom left corner with the green chart, what does that discuss?
The bottom left corner, the max stress orientation.
Right. So Marathon raised the issue of maximum stress orientation in this case, correct?
That's correct.
Okay. But land doesn't have anything to do with that, right?
Correct.
Okay. Mr. Rankin asked about a meeting that occurred or your qualifications and whether you informed Conoco or Marathon of your qualifications. Other than that planned meeting, did Conoco ever ask specifically for your qualifications and experience in regard to drilling these wells?
No.
Okay. Real brief, we're almost done. If we look at A10, exhibit A10 and A11, those are the ownership exhibits. Get up there as fast as I can. Okay, so well, let's just focus on A11. This is the apples to apples. What were you trying to represent with this chart?
This was just, trying to represent the northern portion of the Super Hornet unit, where Conoco / Marathon own all of their interest, as well as me trying to make very, very wide note that I don't view that the northeast quarter of Section 3 is a viable option of being stranded. So I did want to show that regardless if you wanted to view it as a north half development or a south half development, that Powderhorn did have the majority interest committed.
In either case?
Yes.
Okay. So the last thing I want to talk about, this JOA that Kaiser Francis signed with Powderhorn. In your experience as a landman in New Mexico, is it common for parties to sign what is commonly referred to as superseding JOAs?
Yes.
And why would a party sign a superseding JOA?
Because they are viewing another development as a preferred option.
And do you know why Kaiser Francis signed the JOA with Powderhorn in this case?
Because they were worried that, number one, that their interests would be stranded because they own on both the north side and the south side of the Super Hornet unit. They also wanted to see an actual full development of the Wolfcamp A formation across the full sections.
So fair
As a
to
longer lateral development.
apologies. It's fair to say they preferred your plan?
Yes.
Okay. When you're acquiring an interest, whether you have knowledge of an existing JOA in the chain of title, would that knowledge or not knowledge of a JOA have any ability on a party's ability to sign a superseding JOA?
Sorry, can you repeat?
Yeah, no, that was really, I tripped on that. Would a party's knowledge of a prior JOA in the chain of title prevent them from signing a superseding JOA?
No, it would not.
Okay. And so if Powderhorn acquires Kaiser outright and Kaiser signed this superseding JOA, you would take that interest subject to all the agreements that that Kaiser Francis has signed, right?
That's correct.
Okay. Just one quick thing. This trade, just to clarify for the record, you were authorized by the third-party owner of acreage subject to the trade to Conoco that we've discussed in length. You were authorized to present that to them, correct?
That is correct.
And when that deal fell through, you immediately notified Marathon, correct?
You as in Powderhorn, because Jack made that call, but yes.
Right. And so since we discussed some hypotheticals earlier in your cross-examination, as a hypothetical, you offer the deal on February 2nd. Let's imagine a world in which Conoco accepts on the 4th. Would that trade have then been consummated?
No. Sorry, go ahead. Sorry, can you say?
Right. So before the third party pulled the deal,
Okay.
you would have had the ability in that span of like 3-4 days to do the trade with Conoco if they had accepted, correct?
So we still wanted to run an evaluation, like regardless of the third party, we wanted to run an independent evaluation. Conoco gave us some caveats that we weren't sure if it was approved on their end either, so.
Okay. But if you had come to agreement, just from a title perspective,
Yes.
that trade could have occurred.
Absolutely.
Okay. So last question about that. Why did you search out this acreage? Remind me why you searched out this acreage?
So well, it came to us in December, on the December 19th, but in the preceding 6 months, we had received minimal engagement on any real conversations from Conoco. So we had to find something else. We've offered them acreage that we owned under them already. It didn't seem like that was of interest. So we had to find something else. And this kind of came up and we treated it as delicately as we thought we could. None of that was intended to offend anyone. We've worked many deals like this in the past. I've worked on these between Concho and Permian Resources and Colgate, deals just like that, where we've kind of acted as a pass-through entity. And I've never had an issue, and I've never been claimed a bad faith for it. So
And you don't feel like your efforts in this regard were in bad faith, correct?
no, and in fact, like I say, if you look at the communication log between the 5 parties that that Powderhorn has done deals with or reached voluntary joinder with, we have communicated with Conoco the most.
Okay. I believe that's all my questions.
Mr. Rankin, I trust nothing new came up during that?
Nothing new.
Good. All right, Mr. Fordyce, did you have anything else?
I have nothing further, Mr. Hearing Examiner.
Thank you. This witness may be excused. Thank you, Mr. Mock. Okay, now we're going to take a break from the regular course of events, and we're going to have Rankin provide testimony from his petroleum engineer.
Thank you, Mr. Hearing Officer. Dr. Umekwe, are you available on the platform?
Yes, I am.
Thank you very much. Let me know if you have problems hearing me, and we'll let you know the same. Since you've already been accepted as an expert, I'm going to skip through the preliminaries and just jump in to some of the meat. Dr. Umekwe, have you conducted an engineering study of the lands at issue in this contested case?
Yes, I have.
And have you prepared written testimony and exhibits that are marked as Exhibit C and Exhibit C1 as part of your direct testimony?
Yes, I have.
Did you also prepare rebuttal exhibits that were filed and served in this case and marked as Exhibits 5 and 7? And I can share the screen so you can see it, so you know what I'm talking about, because I don't think you probably knew the numbering. But that would be exhibit number 5, this one here.
Yes.
And then exhibit number 7, this one here. Did you prepare those as rebuttal exhibits?
Yes.
Were these exhibits prepared by you or compiled under your supervision?
Yes.
And no corrections or changes to the testimony or exhibits that were filed, correct?
Correct.
And you adopt the testimony that you filed in your self-affirmed statement as Exhibit C as your sworn testimony today.
That's correct.
Dr. Umekwe, I'm going to ask you about your testimony addressing vertical degradation. You've reviewed Powderhorn's application.
Yes, I have.
And you've reviewed their land, geology, and engineering statements that were filed in this case.
Yes, I have.
What's your understanding of what Powderhorn proposes for their development plan based on that review?
Powderhorn proposes to drill the Wolfcamp XY sands first, and potentially come back and drill the Wolfcamp B or Wolfcamp C at a later date.
And just, I know you're not a geologist, but just for purposes of clarification, is there a difference in nomenclature between the parties, what they're calling Wolfcamp B and Wolfcamp C?
Yes, that's my understanding. And my colleague, the geologist who speak to it, Mr. Dupree, will speak to it later tomorrow. But what Powderhorn refers to as Wolfcamp B, we typically will refer to it as Wolfcamp C.
Okay. Now, based on your review and your discussion just now, that they propose to first drill the upper Wolfcamp sand and then come back later to drill the lower target. What is the problem with that development approach based on your review and analysis?
Powderhorn's development approach is going to lead to parent-child, top-down parent-child degradation. And at some point, I'll maybe talk through the exhibit that you have before me, to kind of describe that in more detail.
And when you talk about parent-child effect, you're talking about a vertical parent-child effect between the upper target and the lower target, correct?
That's correct.
Because in their testimony, Powderhorn is referring to a different kind of parent-child effect, a horizontal offset parent-child effect, correct?
That's correct.
Okay, but you're here talking about the vertical impacts, correct?
That's correct.
And you prepared an analysis to show how this is going to be an impact on the vertical side, correct?
Yes, I did.
Okay, so I've got your slide, rebuttal exhibit number 5 up. If you would just review for the examiner what this shows. I think you prepared the slide with your geologist and he'll address the geology aspects of this and you're going to address the engineering aspects, correct?
That's correct.
Okay, so go ahead and give us an overview what the slide shows and then give us your assessment on the engineering side.
Okay, so the slide before shows a few things. I'll kind of walk us through it. So the top left portion of the slide shows a locator map, which shows the relative locations of the Super Hornet project on the top right, on the top left, with the A shown on it, and the ConocoPhillips pilot project that tested this specific phenomenon that we'll be describing today, the potato baby cake shell project, shown on the southeast of that particular image, as shown there. Then below that image, we show the differences between the Super Hornet project, the vertical separation of that project as proposed by Powderhorn versus the vertical separation of the pilot project executed within ConocoPhillips or Marathon Oil. And what you see there is you see a vertical separation difference of somewhere around 100 plus feet, so 610 or so feet for the Super Hornet project versus 720 plus feet for the ConocoPhillips project. Then on the very center of the slide, you see Powderhorn's exhibit and its gun barrel showing its Wolfcam XY wells shown in red, and its Wolfcam B wells or Wolfcam C, shown in green. And those are the wells that it plans to potentially come back to drill after drilling the A first, or the XYs first. On the right, we show the gun barrel for the ConocoPhillips project that tested this specific phenomenon. So on the left side, you have the Potato Baby project, and on the right, you have the cake shell project. And the Potato Baby project is essentially set up, just like the sequential development that is contemplated by Powderhorn. Whereas the cake shell side of the project shows the co-developed project that is proposed in ConocoPhillips Campana project. And below that, we show the difference in performance of the Wolfcam C or Wolfcam B in both scenarios. So the blue line shows us the performance of the Wolfcam C in a co-development scenario, whereas the orange line shows us the performance of the Wolfcam C or Wolfcam B in a sequential development scenario. So the sequential development scenario maps clearly with the plan that Powderhorn has put forward for the Super Hornet project, whereas the blue line shows the plan mapped out in the Campana project.
Sorry, explain briefly, Dr. Umekwe, the engineering principles that govern your analysis and apply in this instance as between ConocoPhillips pilot test project and then the Super Hornet proposal by Powderhorn.
So in general, we're dealing with a few factors. The vertical separation of the two zones that are being developed, as well as the pressure differential between those two zones. In general, pressure increases with depth. So the Wolfcam C will be more pressurized than the Wolfcam A. or the Wolfcamp XY sands as Powderhorn proposes here. And because of that, when you go to stimulate the Wolfcamp C, the fluids that you're injecting into the Wolfcamp C will preferentially move towards lower pressured areas. So it's a natural phenomenon. That phenomenon is exacerbated by the depletion that would have occurred in the A if you drill that first, or in the XYs if you drill that first. So the key issues here would be the vertical separation as well as the pressure differential. In this specific case, you see that we observe parent-child, top-down parent-child degradation in the Potato Baby Cake Shell project, which is over 720 feet separated. So in the case of the Super Hornet project that has a shorter vertical separation, you would expect even much higher degradation. And one thing to note also is we observe this degradation for the Potato Baby Cake Shell project while implementing several steps to kind of mitigate that. So for a less practiced operator, as well as for a shorter vertical separation, you would expect a worse performance for the Wolfcamp B or C, as in this case.
And just to be clear, the results that you identified here in your analysis suggest that the same sort of vertical degradation you expect to be observed in the Super Hornet, correct?
That's correct.
And even perhaps exacerbated because the vertical separation in the Super Hornet is less than what was experienced in your pilot test project, correct?
That's correct.
Okay. And I know we didn't have Marathon's geologist testify in advance of your testimony, but based on your review, do you believe that the pilot test project is analogous to the project proposed by Powderhorn for its Super Hornet?
Yes.
And just for clarifications, the data that you used for purposes of making this analysis was all publicly available data. Is that correct?
That's correct.
And does that track with the internal data that ConocoPhillips has as well?
That's correct.
Now, in your opinion, Dr. Umekwe, is it always appropriate to co-develop a Wolfcamp formation as Marathon is proposing here?
Not in every instance, but in this specific instance, given the vertical separation at play, it's the preferred option for development here.
Okay. Now, would you agree, Dr. Umekwe, that sometimes other factors like drilling deadlines, prior plans, agreements with different partners, all could influence whether an operator is able to carry out its preferred development plan for a given project?
That's correct. I agree to that.
Now, in reviewing Exhibit C4, which is Powderhorn's engineer exhibit here showing a chart. Explain why, in particular referencing the green box, in your opinion, it would be prudent to co-develop the Wolfcamp in this acreage to avoid the potential top-down parent-child degradation that you're seeing in the off-site pilot test.
Yeah, so Powderhorn, based on this slide, from what I understand, shows that the Wolfcamp C is a highly gassy target, so high GOR, like it's stated right there. And they also mentioned that the economics for this will be marginal and made more marginal if parent-child effects are taken into consideration. And I agree with that statement. And I think with top-down degradation, you would be experiencing exactly that and even worse. And that top-down degradation is the plan that has been put forward by Powderhorn in his Super Hornet development. So essentially, the Wolfcamp B or Wolfcamp C project, when Powderhorn gets around to doing it, would be degraded, and the economics for that would be so marginal that Powderhorn may or may not, choose to continue with that.
So the point here is that the concern, the marginal economics potentially with the Wolfcamp B is exactly why Marathon is proposing to co-develop these benches, partly, correct?
That's correct.
In your opinion, in this acreage with the vertical offsets that Powderhorn is proposing, will failure to co-develop the Wolf Camp sand in the upper bench with the Wolf Camp B or C in the lower bench result in waste?
Yes, it will.
In your opinion, will failure to co-develop co-develop those benches in Marathon's acreage impair Marathon's correlative rights?
Yes, it will.
And is that because you believe that it will not access as many reserves if you were to sequentially develop the lower Wolfcamp bench?
Yes, it will not access the resources that exist in the Wolfcamp C bench adequately.
The next topic that I think you set out for rebuttal is Powderhorn's claims for capital efficiency for longer laterals. And I'll turn back to your rebuttal exhibit number 7. And you've included in here an image of Powderhorn's exhibit C6 titled Short Laterals, Capital and Operational Inefficiencies. What is the purpose of this Powderhorn slide as you understand it from Powderhorn's engineer? What is it intended to say?
Powderhorn's slide intends to show a comparison between Conoco's cost AFE versus their cost AFE, and also to show that the 1.5 mile well has a comparatively better use of capital, essentially better capital efficiency. And based on the numbers shown on the slide, you see that Powderhorn's per foot cost would be somewhere around, say, 20% lower than Conoco's AFE cost would show. And what I state here is a claim such as that could be made by more practiced operators, teams with long-standing relationships working together, as well as with trusted and tested contractors, but not with a team that hasn't drilled a well. And what I show here as well is just, again, it's common knowledge that we get better by doing what we do. So in general, that's acceptable. That's accepted. So for Powderhorn to claim that it gets this level of efficiencies on its first well appears to me to be a stretch. What I cite there is a study conducted within the Colorado School of Mines that shows drilling teams that improve on the ability to drill wells much faster and at lower costs, year on year. And those improvements could be, somewhere around 11% or, depending on the situation. So the 20% capital efficiency that Powderhorn speaks to, it is, for me, it's not justified by the experience or lack thereof developing within the basin.
Now, in addition to the drilling efficiencies, Dr. Umekwe, are there additional efficiencies that can be realized through operations?
Yes, there are. Again, efficiencies don't just end with capital and also the execution of a well, the drilling of a well, but also with the operation of that well. Without experience operating wells within the basin, it's hard to believe that Powderhorn's plan and its operational capabilities would allow it to manage what I would say kind of precious reservoir energy, which is kind of the main driver for tight oil development, to manage that energy as well as to keep the wells online when needed. That would require a well intervention program and processes that allow for those wells to essentially have the uptime that you premise in your economics in the first place. So an operator without that experience and those processes might not capture those benefits, and as such might have wells that don't maximize the production of resources, within the zones that they are drilled.
I'm going to turn back to Powderhorn's exhibits, in particular C2. And this is an overview or of a comparison between the competing development plans and Powderhorn's assessment of the advantages of their proposed approach over marathons. Have you had a chance to review this chart on Exhibit C2 of Powderhorns?
Yes, I have.
Will you give us an overview of your response to each of the advantages that Powderhorn represents and your response to those?
Yes, so Powderhorn puts forward 5 or so criteria, under which it judges the Super Hornet development versus the Campana development or the 1 mile development. And the first point there talks about capital efficiency. And like I mentioned earlier, the per foot capital efficiencies don't come naturally. Those are efficiencies that are gained through long-standing working relationships across teams, and as well as across working with tested and trusted operators or contractors. So in the case of the 20% efficiencies that Powderhorn speaks of, there is no evidence that those efficiencies will be gained. Talking about correlative rights and the potential of stranding the zone right at the very toe of the Campana project, like was discussed earlier, Powderhorn has the option of drilling north-south wells, which some of the exhibits shown moments ago show that the development around this area includes both stand-up and lay-down wells. So in that case, the argument on correlative rights and stranding acreage doesn't. I don't see evidence for that as well. On the parent-child effects, like I described earlier, top-down sequential development will lead to a loss of resources within the Wolfcamp B or Wolfcamp C bench. And Powderhorn's statement here kind of attests to that. They say staggered timing causes interference. While that may have been put forward, maybe in terms of in-bench interference or degradation, that holds true still for top-down degradation. Powderhorn also speaks to production efficiencies on stating that the 960 acre spacing unit would produce more per lateral than the 1 mile well. Like I mentioned earlier, production efficiency depends on a lot of factors. Your ability to manage reservoir energy effectively, your ability to keep the wells online, your ability to have essentially a program that allows you to manage the wells as effectively as you had in your plan, essentially. Talking about development coordination and the need for a single operator to develop the acreage, I think I agree with that. It's fair to think that the more experienced operator be let or allowed to develop its own lease. And if there is one operator that needs to develop the entire acreage, it's also fair to think that should be the more experienced operator.
On the production efficiency issue, is it your position that you're not challenging Powderhorn's individual personnel's experience? You're saying that they don't have the team experience proven to drill a well at these efficiencies, correct?
That's correct.
And nor have they worked with the proposed operator as a team, correct?
That's correct.
And because they haven't drilled a well yet, they haven't executed on an AFE that this team has proposed, correct?
That's correct.
And because of that, they haven't demonstrated that they can come within meet the estimated economics for a project, correct?
That's correct.
Nor have they demonstrated that they can meet the anticipated performance metrics for any well that they propose to drill, correct?
That's correct.
In your opinion, Dr. Mekwe, what is the best way for the division to prevent waste and protect correlative rights in this contested case?
It is to allow MRO or ConocoPhillips to develop its acreage in a manner that we know would maximize recovery of resources, within that acreage.
Is Marathon asking for the division to deny Powderhorn's application?
That's correct.
This time, Mr. Hearing Officer, I have no further questions of Dr. Umekwe and make him available for cross-examination.
Mr. Holliday?
Good afternoon, doctor. I'm not going to try to say your name on the record.
Good afternoon.
Good afternoon. But I do have a few questions. If we look at your self-affirmed statement in paragraph 5, it's your testimony that Marathon's planned co-development of all 4 Wolfcamp wells in the XY and Wolfcamp B, it's necessary to avoid parent-child degradation. Am I summarizing that correctly?
Could you restate that, please?
In paragraph 5, you testify that Marathon's planned co-development of all 4 Wolfcamp wells, the A and the B or C, whatever we're calling that, co-development of those formations at the same time, you claim that's necessary to avoid parent-child degradation. Is that correct?
That is necessary to avoid top-down parent-child degradation. Yes.
Okay. So do you believe that if you were to drill multiple wells at different times in the same landing, would that result in parent-child interference?
In the same landing, the setback rules would apply. So if you develop, if you drill wells within a landing and subsequent wells are drilled within that same landing, it will depend on the offsets of those wells.
Okay. And there is offset production to this, correct?
In what direction?
To the north?
I'll have to take a look at the layout again to be able to answer in the affirmative or not.
Okay. So do you believe there, if you drill all 4 Wolfcamp well A wells at the same time, would that result in less parent-child degradation than drilling 2 wells and then drilling 2 more separately?
So each drilling event, I think you have to explain it so I understand. Are you talking about drilling events in the shallower and deeper zones, or drilling events in the same landing, or could you clarify that?
Yeah. So just talking strictly to the Wolfcamp A for this question. If you were to drill all 4 Wolfcamp A wells at the same time, would that result in less parent-child degradation than drilling 2 wells in the Wolfcamp A and then coming back later and drilling 2 more